if I break the matter, it's here the IO lot.
Next Wednesday.
Okay. For a back, document. Item number 9. Thank you for the other station, as well as I have like the other side. I prefer German law. I prefer German law.
What?
What if the English council is out of station? The English council is out of station lot.
Who?
Jesus Ahmed lot.
So what?
Any day next week. Item 9 lot.
Don't mention matters of
Tally withdrawal lot. Three lot.
you want to withdraw.
Withdrawal. Okay.
What's your name?
And go map.
No.
I'm just a
Bring them.
I have not the breath for that.
It is not possible to withdraw at the concert with you. You cannot withdraw. Tomorrow you withdraw it, what will happen? You know the consequences. In the second appeal, what will happen? They will say that we have never asked this person, we have never signed a wakalatnama in his favor. And he has withdrawn this. Isn't it? It would have a serious consequences. This is a 2009 matter. And tomorrow we are in 2024. If you don't appear, you get it dismissed for default. I'm not going to withdraw this at your instance. Sorry. Yes, what is this?
My lord.
Oh, this matter.
Yes.
Yes, just refresh this court. What was the dispute?
Yeah.
What was the dispute?
Dispute, my lord. What has happened is I had dispute for ejectment of the defense. And he is the defense. Suit was decreed ex parte. Subsequently, he had the application under order 930 for vacating the decree as well as the also find that it was condemnation of state of 355 days. That application was rejected, right?
Huh?
That application was rejected by the tribe. Later on, he came in up. At the initial stage, the appeal was then it came before the Honorable Court, and the Honorable Court directed that the appeal be heard. Accordingly, the order was passed on 7/2/2020, my
On
on 7/2/2020 at 16 March
7/7/2018.
20 at page 16.
Page 16.
60. And that application was allowed. Condonation petition was allowed.
And what is your ground?
The reasoning at is at page 20. Page 20.
Yes.
My lord, point number 1. Whether the order that is passed by the court is suffers from an and is liable to trade with their coin. Sufficient force guard may be by the person under order 9. Yes, the order is passed in the as learned shows that within taking part of the company was tried after 345 and the principle of that was taken by the case of the in the present of the program that someone of the both of has and the that the limit of what is the that regarding in painting of the someone on the door of the test. And let us have it on the door of the premises of the appellate in presence of one witness representative Vitali Dekha. The discussion has proceeded to the ex parte against the appellate by protected past acceptance put by the principal only of the basis evidence shown by him is violated with governing order 517 of the ship. In any case, even when the process is covered, so with it off and thereafter in a CCTV holder is to be. In that perspective, the department of efficient. Regarding competence of the budget, this is pertinent mention here that the appellant was engaged with the son who made the accident, and this might be one of the probable grounds for which the appellant was protected. Although the learned conceptual that the absence of cannot be, but such argument no because in all circumstances might not but they that by itself can indicate that someone is so far as come to heart that ignorance and it shapes us about ground in respect of electricity and the layman meant to care about and women and community. But
Yes, what is your ground?
while the ground that put they were put to the explain first and secondly so far the fact of in is that there is a two comply and it is
Huh?
only it is the two comply order 5 270 it is the two comply. It is he who has to examine the processor. And for that one, I cannot take. And the learned trial court also can. So that it is that now, for this particular purpose, may I take your notice to the application which he has filed at page 61.
Yes.
61. 60. There are that the defendant should have filed the application on 4/39/2012, but the same is filed on such and such. Thereby, it is delayed of 345 days as of such and such. That the defendant is to submit that has been expired and soon after the expiry is divorced from the that the defendant is to submit that only some years motor vehicular accident due to motorbike and soon after the accident he was kept busy for the medical treatment and took the severeness it took the heart to better treatment where the driver is paid for treatment. Being the dependent is the mother of the son. She kept attending his son for natural cause, offering of medicines and helping her for taking food her son is still as a medical that the dependent is that the son is required to take food for reference to the it has to I on the bed throughout the day and night. For the accident of the son, the attention of the dependent is the health of the son, and thereby there was sensitivity providing his miscellaneous application. He may undertake produce medical papers and document that the dependent is to submit the detailed that does not know the complicated of law and ignorance of human are often ignored significance of the part of the state that the dependent system is the good side, good stuff. These are the clouds. Now, my lord, your lordship is out.
No, whether she explains or not, but the
Because-
fact remains as to whether the service was duly effected. Because if the
Yes.
service was not effected, she couldn't have known.
Right. Your lordship is
Whether it
absolutely
is
right.
345 days or 400
Yes,
days
whatever
is
may be the
immaterial.
days, my lord, that is much. Now, for this particular purpose, my lord, I am taking to your lordship to page 32. Page 30. That is the report of the process server. Next is the my lord affidavit which he has. He has.
Hmm?
Next is the affidavit. He supported this report by that. And that is the requirement of order 5.
It's civil rules order. Civil rules. What does the civil rules and orders say? Huh?
I have not to have that it is I can say,
Why?
but it says my that is
It's a parted matter.
yes.
Then I think it is rule number 63, if I'm not. Yes. A party shall not ordinarily be required to supply any identifier for the purpose of serving summons or notice or any other person on a defendant, respondent, witness, or other, whether issued by any subordinate court or high court or received from the court outside its jurisdiction, and the service of serving officers shall serve the summons, notice, or process of the due inquiry as to the identity of the person on whom or the house or the property where the same is served. The serving officer shall serve in the presence of at least two independent witnesses, and he shall, whenever possible, obtain the endorsement by the signature or thumb impression of those persons on the original process, and where he is unable to serve the process, he may, whenever possible, obtain the endorsement by signature or thumb impression at least of two persons of the locality. If it appears to the court that sufficient information is not given as to the identity and the place of Iman on the whom or if the person is examined from, so how many persons were there?
There was only one person, one witness.
So the civil rules and orders says two persons.
That is right, man. But even though so far here order 5 to 17 is concerned,
This is order
that
5
is-
rule 17.
it speaks only one person.
Kindly
only
see
witness.
65. 65. If the person addressed is absent from his residence at the time of attempted service and there is no likelihood of his returning there within reasonable time, and there is no agent empowered to accept the service on his behalf, nor is any other person on whom the service can be made, service have been effected in the manner directed under Iman. The report of the service should state the grounds of his belief that the person was absent from Iman at the time of attempted service, and there was no likelihood of his returning within a reasonable time, and there was no agent empowered to accept service, nor any other person on whom service could be made, and in any case, that on the door of the outer house or other conspicuous on which a copy of the affair was affixed was the ordinary residence or the place of the person at that address at the time when it was fixed. If the service is made under Rule 15, now let us see. Does he say, to him affirm that on Iman I went to the address mentioned in the summons, and on being searched I did not meet the addressee at home. I met the son at her home and handed over the notice and copy, but after going through the same, he refused to receive the same. Therefore, by taking back the notice and copy from the son, the notice of the copy was affixed on the door of the addressee in presence of the aforesaid witness. Where is it? He said that he had, and there is no reasonable time within which he would not be, this person would not be available.
So much it is not there.
Then, you see, isn't that the most pertinent? If we see order 7, rule 5, rule 7, the serving officer shall affix a copy of the summons on the outer door of the so-and-so, a part of the so-and-so, and shall return the rear, and it was there with a report endorsed or annexed as stating that he had affixed the circumstances under which he did so, and the name and address of the person, if any, by whom the house was identified and in whose presence the Iman. Then the basic is who is absent in his residence at the time, and when the service is sought to be on him or at his residence, and there is no likelihood of being found at the residence within a reasonable time.
His son, her son was what?
And
Hudson?
this aspect was brought in by the 1976 amendment. This particular thing that there is no likelihood of him being found at the residence within a reasonable time.
Yes, that is more, but it some was, but
So, understood. The son did not take it.
Take.
If the son doesn't take it, then how do you affect?
and he could,
You can affix it out there.
yes, and is not so elaborate. So far the report. But the report does not say that he did not make any attempt make the search on her.
But the report categorically says one thing to the effect that there is, the report does not say anything that there is no likelihood of him being found at the residence within the reasonable time.
Yes, that aspect is not.
Then how do you accept that report? That is an amendment being made to the statute. And if that is an amendment, don't you think that the legislature thought it that the requirement of that aspect has to be mentioned in the affidavit? Without
Yes,
that, how can you? How?
Oh, so far the
I would not say that there is a requirement of examination of that area. I would not say that. The examination of that person concerned, no, that is not required. That is not the mandate of Order 5, Rule 17. But the fact that the examination, if you had made at that point of time, it could have been looked into.
Okay, my lord, so far the suffer it's a he so far the really
There
for
cannot be actually the service of by a process server cannot be in a hurry. He just goes out there. Therefore, nowadays we have that particular. It's a very important. Yeah, what is that, Mr. Gogoi? What is that? That nowadays you have that particular Napora. What is that? When a process server goes, it is seen. There is a particular instrument he takes.
Yes.
The name I forgot. There's a machine he takes with him.
Yes.
The moment it is served,
Yes.
he just puts that with the GPS.
Yes.
And then it is known
Now
that
it is. Now it is.
nowadays.
Now it is.
Now it is now the technology has.
But this is not that. And you could have. You should have asked for examination of that witness. He could have cross-examined him. That is one aspect. But you could have examined him. That is why the requirement of an examination. That when it is done through doing it out there.
Since it was on affidavit, and that's why I did not think that there's that requirement.
Because the affidavit does not contain that aspect.
Yes, that aspect, but one thing, my lord, he was not aware. And this
Understood.
son
He is
could
not a, but the question is
This son
whether
could-
she would not be available or if there was mention out
not-
there.
could not wait when
And,
she will come back.
On all
How
these
we will
things are
assess
very
my
well
lord?
understood. But Mr. Bhatti, the question is, if he had written one line out there to that effect, that when I asked the son said that she would not be available. That line was there in this report. I would not have touched it. That was the most essential thing. Because otherwise, you see the implications. This has serious implications. It will be served like this. This is an application under section 115. Is it 115?
Yes.
Of the Code of Civil
No,
Procedure.
No, my lord, it was an appeal. My application.
115.
Sorry.
No, here it's 115.
Yes.
115 of the Code of Civil Procedure. Challenging the order dated 7/2/2020 passed by the learned civil judge number 2, Kamrup Metro, in Miss Appeal number 09/2014, whereby the order dated 19/3/2014 passed in Miss J case number 384/2013 by the learned Munsif number 3, Kamrup Metro at Guwahati Metro was set aside. The brief facts which led to the filing of the instant proceeding is that the petitioners herein had filed a suit being title suit number 263 of 2010, seeking eviction of the defendant from the tenanted premises on the ground that the defendant failed to deposit the rent, pay the rent for the tenanted premises from August 2009. In the said suit, upon summons being issued, the process server went to the address as mentioned in the summons, but did not find the defendant. Thereupon, the process server met the son of the defendant, but he refused to accept the summons. And accordingly, the process server affixed the summons on the door of the premises of the defendant in presence of a witness. Pursuant thereto, the process server submitted a report on 23/12/2011, where's the affidavit along with an affidavit on 2/11/2012. On the basis of the said process server's report, the court of the Munsif, number 3, Kamrup Metro at Guwahati, proceeded ex parte against the defendant and passed the judgment and decree on 3/8/2013 in title suit number 263 of 2010 in the said suit. The defendant, on coming to learn about the said judgment and decree, approached the learned trial court by filing an application under Order 9, Rule 13 for setting aside the ex parte judgment and decree on the ground of the summons having not been served, on the ground that the summons were not duly served. Full stop. Along with the said application was registered and numbered as that was not registered. Mr. Bora,
Why not?
that application was not registered.
Condemnation petition was registered,
The
but
other one
otherwise not registered.
was registered as petition number 2319/2013.
Yes.
Full stop. Along with the said application, an application was filed under Section 5 of the Limitation Act for condoning the delay of 345 days in preparing the application under Order 9, Rule 13 of the Code. To the said application, you file objections to both the applications?
My lord, may I point out one?
Hmm.
So far, their application or the section 5 of application 8, there is nothing to show that it did not.
Huh?
It did not receive the summons. There is no statement
Where?
in the condonation.
Section 5. Section 5, it is not there, but it is there in that application. That is what I looked into. But that application would be a boon to you. Take a certified copy where she duly accepts that she had not paid the rent.
That is
Page number 69 of the petition under Order 9 Rule 13. Ground number one specifically.
I've seen that. And that ground number D, I suppose, he categorically says that she requested she went out there, she could not pay the rent, and later on when she came and wanted to give the rent, the plaintiff did not accept. So this is a clear admission.
yeah.
In respect to both the applications, the plaintiffs submitted written objections. The learned trial court by an order dated what is this execution application file?
That I,
Hmm?
that I had for execution of it.
When was this filed?
After obtaining the DPMS, the exact date I cannot say.
And when did she file that application?
Yes, that was dismissed. That was dismissed.
When
When was that application filed? The Order 9 Rule 13?
13 is what I lord.
13 4/8/2013.
4/8.
4/8/2013.
Okay.
After filing the execution case, my when
Yes. Petitioner came to know 8/8/2013 about the pendency of the suit and execution procedure.
The learned trial court, that is the court of the Munsif number 3, by an order dated 19/3/2014, dismissed both the applications stating that the statements made by the defendant, who was the petitioner to those applications, were not tenable in law and facts and were not supported by documents or evidence. Being agreed, an appeal was preferred by the defendant, which was registered and numbered as misappeal number 9/2014. The learned court of the civil judge number 2, Kamrup Metro at Guwahati, by an order dated 7/7/2018, dismissed the said appeal, thereby upholding the order dated 19/3/2014 passed by the learned trial court. Being agreed, the defendant preferred a second appeal against the order, being SAO number 9/2018, before this court. The said SAO number 9/2018 was withdrawn with liberty to file a revision. Accordingly, the defendant filed a revision, being CRP number 33/2019, before this court. And by an order dated 13/3/2019, this court allowed the revision application by setting aside the order dated 7/7/2018 passed in misappeal number 9/2014 by the first appellate court and remanding the same to decide it afresh, considering the observations made in the revision application. Accordingly, this court directed the parties to appear before the appellate court on 25/3/2019, and the first appellate court was directed to dispose of the appeal within a period of 1 month from the date of appearance. It is under such circumstances that the impugned order was passed, thereby setting aside the order dated 19/3/2014 passed in Mizze case number 384/2013, and with a direction to the parties to appear before the learned court below for a decision on the petition number 2319/2013 afresh for consideration regarding setting aside the ex parte judgment and order passed in title suit number 263/2010. It is against the said order dated 7/7/2020 that the instant proceedings have been initiated. But Mr. Bhatte, what type of order is this?
Yes,
The court
appeal
should
ought to
have-
been, appeal ought to have been decided.
Now, understood, the court have only taken into account the appellate order, only the injunction there. You see, the thing is like this. Once an revision is dismissed or an application under Order 9 Rule 13 is dismissed, on the ground of limitation, it amounts to a dismissal of the Order 9 Rule 13. And there cannot be an appeal against an order under Section 5. The appeal should have been against the order dated order passed in Order 9 Rule 13.
That is,
So what remains? We should vacate direct the suit to be decided.
Yes.
Unnecessary. Once I make that observation, the trial court will do that because it is not being done. And this is what the entire appellate court decided, that the service under Order 5 Rule 17 was incorrect. And if that be so, can the trial court then say, no, the appellate court was wrong? This court had duly heard the learned counsels. Now, Mr. O.P. Bhatti, the learned counsel appearing on behalf of the petitioner, submitted that the learned first appellate court erred in law as well as also on the facts in not taking into consideration the report of the process server, which was supported by way of an affidavit, wherein it has been categorically mentioned that on 23/11/2012, the defendant being absent, the summons were duly handed over to her son, who upon refusing to accept the same, have pasted the summons in the premises of the defendant. He submitted that there was no cross-examination by the plaintiff, by the defendant, to the process server. And as such, the examination, and as such, the question of examination of a process server, even after submitting a report on the basis of affidavit, was not at all required. He therefore submitted that the entire premises on which the learned appellate court have decided the appeal was erroneous, for which an interference is required to be made by this court. On the contra, Mr. L.K. Bora, the learned counsel, appearing on behalf of the defendant, who is the respondent herein, submitted that a perusal of the process service report is not in consonance with the provisions of Order 5 Rule 17, as well as Rule 65 of the Civil Rules and Orders, as framed by the by this court. And as such, the process server's report could not have been made the basis for accepting the service of summons upon the defendant. The learned counsel submitted that there is no other materials on record to show that the defendant herein had knowledge about the suit. And as such, immediately on coming to learn about the decree so passed on 8/8/2013, the defendant approached the court by filing an application under Order 9 Rule 13 along with an application under Section 5 of the Limitation Act. Therefore, the delay was duly explained, and as the service of the summons was not duly served, the learned trial court ought to have exercised the powers under Order 9 Rule 13 for setting aside the ex parte judgment and decree dated
3/8/2012.
3/8/2012. This court, upon hearing the learned counsels appearing on behalf of the parties and also upon perusal of the impugned order dated 7/2/2020, with a pointed query upon the learned counsels appearing on behalf of the parties that as the instant case pertains to an application under Order 9 Rule 13 on the basis that the summons were not duly served, and the defendant duly appeared, and the defendant filed the application under Order 9 Rule 13, upon coming to learn about the execution proceedings on 8/8/2013. Does any further is it required further after the order being passed by the First Appellate Court for the learned trial court to again apply its mind to the application under Order 9 Rule 13? More so when the learned First Appellate Court had categorically held that the service of summons in terms with Order 5 Rule 17 was not of the code was not in accordance with law. The learned counsel appearing on behalf of the parties duly submitted that the observations so made by the learned First Appellate Court renders a further adjudication on the application under Order 9 Rule 13 ineffective, inasmuch as the learned First Appellate Court have duly held that the order that the accepting of the summons, accepting of the service upon the defendant in terms with Order 5 Rule 17 was not in accordance with law. Taking into account the above perspective, this court therefore is of the opinion that the question which requires to be adjudicated is as to whether the service of summons upon the defendant was in accordance with the provisions of Order 5, Rule 17 of the court. More so when there is no other materials on record being produced by the petitioners herein, that pursuant to the acceptance of the service of summons upon the defendant, there was any other attempt, any other means to show that the defendant was in know of the pendency of the suit. In this regard, this court finds it very pertinent to reproduce the contents of Order 5, Rule 17, which is done so as herein below. Further to that, this court also finds it relevant to take note of Rule 65 of the Civil Code Rules and Orders of the Guwahati High Court, which is also quoted herein below. A perusal of both Rule 17 of Order 5 as well as Rule 65 of the Civil Rules and Orders show as to when the process server can affix a copy of the summons on the door of the outer house or some other conspicuous part of the house of the residence or place of business of a person's address at the time when it is so affixed. The requirement as per the above rules is that the defendant or the person addressed in the summons is absent from his or her residence at the time of attempted service. And the second requirement is that there is no likelihood of the defendant or the person addressed returning to the premises within a reasonable time, and there is no agent empowered to accept the service on his or her behalf. Rule 65, as quoted above, also shows the report of the serving officer should state the ground of his belief that the person was absent from his residence at the time of attempted service, and there was no likelihood of his returning within a reasonable time, and there was no agent empowered to accept the report, nor any other person on whom the service could be made. In the backdrop of the above, if this court now takes note of the service report, which is Annexure C to the instant proceedings, the translated portion of the said service report is reproduced herein under. number 2365 to Bangkomia 1912. Page 32 and 33 is quoted herein. From a perusal, the parties herein duly agree that the translated version of the said service report is a correct translation to the Assamese version of the service report. Next. From a perusal of the said service report, it would be seen that there is nothing mentioned in the service report about the grounds of the belief of the process server that the defendant who was absent from his residence at the time of attempted service, there's nothing mentioned in the process server's report that the defendant was not, that there was no likelihood of the defendant returning to her residence within a reasonable time. Under such circumstances, this court further finds it very pertinent at this stage to observe that the words inverted comma, who is absent from his residence at the time when the service is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence within a reasonable time, inverted comma close, was inserted to the provisions of Order 5, Rule 17, right, that the Code of Civil Procedure Amendment Act of 1976. Under such circumstances, it is the opinion of this court that when the legislature has specifically inserted the requirement when the affixing of a note summons can be done by stipulating the twin conditions that the defendant is absent from his residence at the time when the service is sought to be effected, and there is no likelihood of his being found at the residence within a reasonable time. The requirement has to be met in the process service report. The learned trial court, while accepting the summons on 27/1/2012, failed to take note of in its order, failed to take note of the said aspect of the matter and accepted the report of the process server dated 23 12 12 or 11 23/12/2011 and the affidavit which was under such circumstances, as the service upon the defendant was not effected in accordance with law, the same could not have come within the ambit of a process being duly, the summons having been duly served. Under such circumstances, this court is in agrees to the conclusion of the learned trial first appellate court that the service of summons upon the defendant was not effected in accordance with Order 5, Rule 17 of the Code, but however, for different reasons. Accordingly, the consequential effect of the summons not being duly served and there being no other materials shown in the objections filed to the Section 5 application for condonation of delay, that the defendant had notice about the suit thereafter also. This court is of the opinion that the delay of 345 days was rightly condoned by the learned first appellate court. Accordingly, this court therefore sets aside the judgment and decree dated. What is the date? The ex parte judgment and decree dated
03/08/2012. 3/8/2012.
3/8/2012, passed in title suit number 263/2010. The learned, taking into account that both the parties are duly represented, the parties are directed to appear before the learned trial court on 3rd of June 2024. On that date, the defendant is directed to file, is given the liberty to file the written statement. Failing to do so, the court shall proceed in the suit in accordance with law. This court further makes it clear that, taking into account that in the passage of time, the litigations have been pending for the last 14 years, and the suit having now been relegated back to the stage of pleadings, this court requests the learned trial court to dispose of the suit, preferably within 8 months.
But
file your written statement.
don't take the plea that supplied.
Eh?
Don't take the plea that he has not been supplied with copy of the plea.
It is there.
Yes.
No, yes. I have received. And the materials are herein. I felt.
Don't, yeah. File it.
Must have been.
Yes.
I am
What is
for-
this matter?
I am for the respondent number 1 and 2 my I was explaining the original the suit was dismissed, then the suit was
Whether the
dismissed, then
impugned judgment and decree is sustainable in law on the basis of exhibit 1 on page 6. Yes, what is the plaintiff's claim?
it's a suit for declaration of right that and
On what basis?
have only memo of appeal was served mine.
Huh?
I have got a memo with I am for the respondent minor.
Understood.
Respondent plaintiff, the suit was filed for right that interest and
Under
for,
what is your document of title?
yes, my lord. I purchased the suit then by exhibit 1, that is Kacha deed my lord, by from the father of the defendant number 1 to 6 my lord. And possession was delivered on that day. For confirmation of possession,
What was the value of the deed?
I purchased this suit then at rupees 4,500. 4,500.
Then how can there be a kacha deed?
Yes, madam. The purchase by Kacha deed method.
Then
And defendant's case is that they denied our case.
let us see how does the trial go. Problem, the appellant is not represented.
Yes, madam.
He has a case. Both concurrent.
No, my lord. First, our suit was dismissed, my lord. Then we preferred appeal. Appeal was allowed. Against that matter, the second appeal is filed.
There is a counterclaim also.
Yes, my lord. But counterclaim was dismissed. No appeal was filed. Counterclaim was filed by pro forma defendant.
Show me your plaint.
Yes, my lord. Not daily, my lord. Only memo
got it.
appeal was served. So
Wrong order. Order is very wrong. Why it is not being represented? You don't have a case, madam. Where is Mr. Mahmood? Anybody of junior of Mr. Mahmood? Yes, you come. You are a junior. Yes, madam. Come. You are a junior of Mr. Mahmood. Fantastic. You just wait there. I'm allowing the appeal in your favor. You don't have a
Lord,
case.
it may be
Madam, you don't have a case. How on earth can, on the basis of a catch-up, understood, you could have made a case under 53A.
with my
You have not. Your simple cases you have purchased on the basis of a kacha sale, unregistered sale, and how could the first appellate court decree the suit granting you right title and interest over? Is it inconceivable how this could happen? You don't require any other thing. It's a simple, that is why I asked you, what is the value of the ring? You say that you have purchased at 4,500. 100 rupees below, I could have understood. Okay, madam, you take your credit today. Getting an your appeal allowed. Yes, I'm coming back in 5 minutes. Get your name ready. Allowing the appeal. Only two. You want your name to be included, I can put your name and ask you. I want an appellant. Otherwise, then other consequences, I have to dismiss the appeal. So better off. I am held up. So it is not required. Appeal has to be allowed. It is absolutely unjustified.
Mr. D. Bora, junior of Mr. Habib.
You are there? You are there. Can I put your name?
Actually, was
Art.
quote
You
number
go.
3.
Not there. Art with the MU Mahmood, the learned counsel appearing on behalf of the appellant. And with Kuswa appeared on behalf.
respondent number 1 and 2. Respondent number 1 and 2.
Respondent number
1 and
This is an appeal under section 100 of the Code of Civil Procedure 1908, for short the code, challenging the judgment in decree dated (30/11/2004). No, dated 3/12/2005. Passed by the Court of the Civil Judge, Senior Division, Borpeta, entitled Appeal Number 15/05, whereby the judgment and decree dated 30/11/04, passed by the learned Civil Judge, Junior Division Number 1, Borpeta, entitled suit number 26/2003, was reversed. This court, by an order dated, madam, take a seat. (31/5/2006), admitted the instant appeal by formulating the following substantial question of law. The question arises in the instant proceeding as to whether the said substantial question of law so framed on 31/5/2006 is involved in the instant appeal. In order to ascertain the said aspect of the matter, this court finds it relevant to take note of the facts leading to the filing of the instant appeal. The respondent number 1 and 2 herein, as plaintiff, instituted a suit being titled suit number 26/03 before the court of the civil judge, Junior Division, Borpeta, seeking declaration of their right, title, interest, possession over the suit land, as well as for permanent injunction. The case of the plaintiffs, as set out in the plaint, is that a plot of land measuring 4 bighas, 1 katha, 18 lecture, which have been specifically described in the schedule to the plaint, originally belonged to one late Abdul Mujid. It was claimed that the said Abdul Majid sold the suit land to the plaintiff number 1 by the deed dated 5/2/1980 for a consideration of rupees 4,04,500 and delivered the possession to the plaintiff on the same day. Thereupon, the plaintiff have been paying the land revenue in his name. Plaintiff number 1 has been paying the land revenue in her name after recording her name in the record of rights. The defendants herein, the defendants were the sons of late Abdul Mujid, who threatened the plaintiff on 15/2/2003 to dispossess the plaintiff from the suit land. And it is under such circumstances the suit was filed seeking declaration of the plaintiff's right, title, and interest, possession, confirmation of possession over the suit land, for declaration for possessory right of the plaintiffs over the suit land, and for permanent injunction. The defendants jointly filed a written statement denying the claims of the plaintiff, the claim of the plaintiff. It was stated that the late Abdul Mujid never transferred any portion of the suit land to the plaintiff number 1, and the defendants have been all along in possession of the suit land of their father. On the basis of the said pleading, The learned trial court other defendants also filed their written statement. In addition to that, it is also seen that a counterclaim was also filed by the defendant, numbers 1 to 6. On the basis of the said pleading, the learned trial court framed as many as 10 issues. Issue number 3 related to as to whether the plaintiff number 1 purchased the suit land from Abdul Majid on 5/2/1980. And accordingly, the plaintiff acquired right title and interest over the suit land. Issue number 4 related to as to whether the plaintiff had been possessing the suit land from the day of the purchase. Issue number 7 to issue number 10 related to the counterclaim of the defendants, which, however, being not relevant, is not being taken note of. Taking into account that the said counterclaim was dismissed and there has been no appeal filed there against. The learned trial court, by the judgment and decree dated 30/11/2004, dismiss the plaintiff's suit and a counterclaim of the defendant number 7 to 14. So, 7 to 14. Being aggrieved, an appeal was prepared by the plaintiff which was registered and numbered as title appeal number 15/2005. The learned first appellate court decreed the suit of the plaintiff, and it is under such circumstances the instant appeal has been filed. This court have heard the learned counsel appearing on behalf of the appellant as well as the counsel appearing on behalf of the respondent number 1 and 2. The question of law so formulated is in respect to issue number 3. As to whether The plaintiff number 1 purchased the suit land from Abdul Majid on 5/2/1980 and whether the plaintiffs acquired right, title, and interest over the suit land. The learned trial court had decided the issue number 3 against the plaintiff on the ground that the document on which the plaintiffs claimed title, plaintiff number 1 claimed title over the suit land, was an unregistered deed of sale and was held by the learned trial court that in view of Section 54 of the Transfer of Property Act 1882, read with Section 17 of the Registration Act, no title devolved upon the plaintiff to transfer in favor of the plaintiff as Exhibit 1 was an unregistered deed of sale. This court further finds it relevant to take note of that the learned First Appellate Court completely learned First Appellate Court had decreed the suit on behalf in favor of the plaintiffs on the basis of an unregistered deed of sale. On the ground that the plaintiffs were possessing the land peacefully from Exhibit 5, Exhibit 1, and it was found from the oral evidence that the plaintiff had acquired their right, title, and interest over the suit land, and they were possessing the suit land from the date of their purchase. It is under such perspective this court needs to take note of as to whether the substantial question of law is duly involved. In this regard, if this court takes note of Section 54 of the Transfer of Property Act 1882 and Section 17 and 49 of the Registration Act 1908, no title, no rights, title, or interest over the suit land would have been transferred in favor of the plaintiff number 1 on the basis of the unregistered deed of sale dated 5/2/1980. The learned First Appellate Court completely erred in not considering the said provisions of law, and more so when the learned trial court have duly taken note of those provisions of law. Accordingly, this court, finding that the said substantial question of law so formulated being involved in the instant appeal, sets aside the judgment and decree dated 3/12 or 3/12/2005, passed in title appeal number 15/05, and restores the judgment and decree dated 30/11/2004, passed by the learned Civil Judge Junior Division number 1 Borpeta in title suit number 26/2003. The LCR be returned to learned trial court. No, this court further allows the instant appeal, by allowing the instant appeal, quantifies the cost of the instant appeal at rupees 11,000, which shall be paid by the, which shall be, and imposes cost of rupees 11,000 upon the respondents who are the plaintiffs, respondent number 1 and 2 who are the plaintiffs, for the instant proceedings. In addition to that, the defendants number 1 to 6 shall be entitled to cost throughout.
That cost will not be.
No,
my
no,
lord.
cost is there,
No, my
minimum.
lord.
That is 11,000 is there.
Very poor person, my
Feel-
lord.
That's LCRB. Cost is there. Is it not there in the trial court?
The very poor person, my lord.
Poor reach doesn't apply. Poor reach does not apply. Can't help it. It's the cost which is mandatorily required in view of Section 35. I'm not imposing cost on any other aspect. The cost is there, a pendency of a proceedings for such a long time, engagement of account, he has to get
But it may be based. my
Item
lord.
number 2.
next. Yes, what is this?
The plaintiff in this case. Up to the truth was dictated, my lord, for a specific performance.
Suit for specific performance.
Yes.
Then
For agree.
you filed the suit.
Yes.
For specific performance.
Yes.
Suit was dismissed.
Truth was decreed, my lord.
Then
Then in appellate court, it was appeal was allowed. Against that second.
and why are you bringing section 20? 20 is what? Discretionary. What does section 20 say? We have to look into section 20 as it stood earlier, na? Purana.
Here in this case, that estimated the land was mortgaged by the principal interest of the one who won to Polita. And then he could not pay the mortgage money. And ultimately, if the plaintiff was requested to pay the amount which was due for against the mortgage, and the entire student was assessed at 5,000, and 5,000 amount was received by the petitioner interest of the respondent. Accordingly, the mortgage money was paid by the plaintiff. Then this the interest of the plaintiff, and transfer on the sale deed, it was the land was returned to the plaintiff interest and put into possession. And before dying, before the death of the petitioner interest of the respondent, he asked his son, Somere's penalty is here is the number one, to execute one deed of agreement to sale. That the sale deed will be executed accordingly. That is exhibit 2 here, and it was proved, though it is denied by the written set. And the appellate court dismissed the suit on the basis of the right of redemption on interpretation of the section 61 of the law. This is the case. The right of redemption, my lord, that's it.
Let us see your claim. Where is it?
Claim it at the page 40.
Page?
Page 40.
On 4?
40.
You are the plaintiff.
Yes.
When was the agreement entered? 11/12/1981.
Yes. This case, the defendant side deduced no evidence.
Did they cross-examine you?
Okay.
What is the stand of the defendant?
Defendant stand is that they have the right of redemption and the mortgage property was not received in accordance with law, which is kind of
Now, what do they say about the that agreement?
regarding the system of dealing of
Agreement. There is an agreement, na?
agreement that has been denied.
11/12/81. Paragraph number
13.
8. Do they deal with paragraph?
Case of defense. As stated in this paragraph 11, 12, the defendant did not execute any document.
Okay. So 81 is your deed. They have denied the document.
It was proved by
Let us see how it was given. Trial court judgment.
page 31.
Put is barred by limitation whether there is any contract between plaintiff. So there is a decree passed.
Yes.
appellate court reversed only on the point of section 60 for the transfer of they got the right of redeem. That's what not done. There was another right of redeem. Right of right of that was here it is.
Now, the defendant was the son. Now, the defendant have duly agreed, had executed the deed.
Yep.
The appellate court did not say that the defendant did not execute it,
Yes.
but said
Only
that it could not have been transferred on account of section 60. But what do you say is the defendant now? What do you say about the mortgage which was being created? Is a mortgager can always transfer the property. It will be, however, subject to the mortgage.
interest is
The property can very well be transferred,
Yes.
but it will be subject to the mortgage. One. Secondly, what do you say about section 13 of the specific relief? What does it say?
regarding imperfect title.
Yes, that is why this is very relevant. After that person has died, he may not have a title at that point of time. But with the devolving of the title later on,
Yes.
wouldn't section 13 be hit? Take care of your right.
Although this being legal here and representative defendant, the two who received the money and he asked his son to come into an agreement for execution of the sale deed. And then, my lord,
Where person
Yes,
contract
right of
to
reading
sell
to-
or let out certain immovable property having no title or only an imperfect title, the purchaser here subject to the above has the following right. If the vendor
has the
or the lessor has subsequently to the contract acquired any
interest.
interest in the year, the purchaser or the lessee may compel him to make good the contract out of such
Yes.
interest. So even otherwise also, in view of section 13A, the trial court ought to have granted
When section
the
40
stipulation.
43 of 43 of the Transfer of Property Act
What does it say? 43?
transcribed by an unauthorized person subsequently acquired.
No, no. It is 43 will come only when there is a transfer being made. 43 won't come here. Here, I think section 13
Section
will.
13.
Now, how this court will bring in section 13 with these questions?
Questions of law came to
Huh?
see in respect of the
You have come up with 20. What is 20?
section 60. Not,
How does 20 come in? Substituted performance. What is substituted performance has to do with it? The jurisdiction to decree a specific offense discretionary and the court is not
The-
bound to grant such
Six-
relief
six
merely
six
if it is
of-
lawful to do so.
six-
But the discretion, huh?
six-
Section?
substantial question of law 6. Number 6. Whether the judgment and decree passed by the learned appellate court are vitiated on account of
But that is not the question of law framed. That question of law has not been framed. Only two has been formulated, whether the judgment and decree passed by the learner is illegal for not considering the provision of section 20. This goes against you. Whether the learned lower court committed illegality in construing the provisions of section 60 of so and so. That is also not necessary.
the possible
Because without framing it, one can't. But what has happened to the respondent? Where is the respondent?
respondents are absent.
Huh?
Respondents are absent. They are order for paper notice. If I read the paper hereafter, they are at the very beginning they have no interest at all. I am in possession of the land.
No, after this order, 38/2023, is there any order passed by this court accepting? Appellant directed to issue notice 38/2023.
And it was advertised in paper
When? There is nothing mentioned about the advertisement.
subsequently.
Because tomorrow what will happen is
Service
we'll have a,
was-
I do it, then they will come
service
up, the
was
service is not
taken
done.
as complete manner. I would-
Earlier they were represented because here what has happened, Mr. M. Quilter, learned counsel
have
for
got
the
the paper.
respondent submits that earlier conducting counsel Mr. Arya had expired and during his lifetime he has written a letter to the respondent expressing his intention to withdraw the wakalat. I've heard the learned counsel Ms. G. Deka for the appellant. Under such circumstances, this case is adjourned, the hearing is adjourned today. appellant is directed to issue notice to the respondent list after 4 weeks. Now, after that, what has happened? There's no office note. No,
To file the paper also, where it is
but it has to be
Yeah,
recorded where? How did you file the paper public? When? Paper publication, which date?
Yeah.
When?
in
Date?
Assam Tribune, it was on May 31, 2018.
2000?
18.
No. Thereafter, after appellant is directed to issue notice to the respondent, what have you done on 3/8/2023? Nothing.
We have taken steps regarding
We do one thing, we frame an additional issue here. And further, take steps. Because that paper publication is different. That is nothing because there is already an order.
we take it.
The instant matter he was heard at length. Upon hearing this court finds that in addition to the substantial questions of law so formulated on 3/12/2018, an additional substantial question of law is required to be formulated. Whether the learned trial court or first appellate court was justified in reversing the judgment and decree passed by the learned trial court without considering Section 13 of the Specific Relief Act 1963. In as much as the Court of Facts have not interfered with in as much as exhibit, what is that exhibit?
Exhibit
Exhibit
agreement.
in as much as exhibit 2 was duly proved. As has been held by the court below. Think that this court, however, finds it very pertinent to take note of that on 3/8/2023, the appellant herein was directed to issue notice upon the respondents. Thereupon, no notice have been affected. There no steps have been taken in that regard. Respondent number 4 is struck off. Is the performer respondent?
Pro forma.
You want to struck off?
He, yes.
Huh?
He did not-
Unnecessary.
He did not contest.
Mr. D. Chaudhary, the learned counsel appearing on behalf of the petitioner, appellant submit that respondent number 4, as well as his legal representatives, had never contested the instant proceedings. Accordingly, he therefore submits that the name of the respondent numbers 4A to 4H be struck off. This court accordingly strikes off the names of the respondent number 4A to 4H. The appellant is directed to take steps upon the respondent numbers 1, 2, and 3. By way of registered post with AD,
I registered for earlier also.
take by way of trustee.
By paper notification.
No. Paper
Then registered for
registered post. Why not trustee?
where they reside at present.
Then how, if you don't know, how can you take registered post?
That is why paper advertisement. Good. Earlier also,
Try to take it by way of trustee. Let's see. See, paper advertisement would be again now a huge cost because I have to give it in two papers, Smith and English. So let us first write up the by way of the stick. Upon the respondent numbers 1, 2, and 3 routed to the registry of this court and to file an affidavit of service on or before the next. The service by way of the stick can be effected to an advocate clerk, and however, the affidavit has to be filed by the person who has effected the service. List the matter again on 18th of July 2015. Then only we can go for paper. Paper is substituted, na? How can you go
Yes.
for substituted on the first?
That is correct.
That is secured by the government. That is secured by the government.
Huh?
That is secured by government. That is close
Matter is,
secured by government.
land has been acquired by the government.
Yes. It's totally land.
Yes, Lordship, that you received the same instruction about.
What?
That the suit land has been acquired by the government. Matter is become infrastructure.
Then
Toji Patta land. The Toji Patta land, Lordship.
it's a Tozi Patta land. It has been submitted by the counsels appearing on behalf of the appellant as well as the counsel appearing on behalf of the respondent that the land in question is a government land
Government.
wherein the both the plaintiff and the defendants were fighting as regards their possessory right. It has been further submitted that in the meantime, the land has already been taken over by the government, and as such, nothing remains to be decided in the second appeal. So, taking into account the said submissions so made by the learned counsels, the matter stands dismissed as infructuous.
Obliged.
Healthcare be returned to the
Oh. Second appeal ballot. Second, I was the defendant ballot. Suit of the plaintiff was decreed ballot. Suit for a specific purpose was filed. The appeal also filed. I filed appeal.
Huh?
It was concurrent finding ballot. I was the defendant. There are two-
where substantial questions
Yes.
of law are
Madam, there are two substantive first substantive question initially at the time of admission was framed whether the learned first appeal court is justified in upholding the judgment and decree.
wait, let me, whether learned person is justified in upholding the judgment and decree passed by the learned without accepting any finding relating to the readiness and willingness of the plaintiff to execute its part of the contract.
But subsequently, as the matter came up for hearing, madam, one additional substitute question has been framed.
Order 41, Rule 31. So, the suit was filed by
The part-
plaintiff
Yes.
seeking specific performance
performance
of an agreement for sale.
agreement.
The suit was allowed
Allowed.
and then an appeal filed by you.
Ma-
That appeal got dismissed,
Yes.
for which you are here.
Ma-
Did he state in his plain pleading that he was ready and willing to perform
Yes, so that part, my lord, has been, that is the issue, my lord. One of the substantial questions that,
Let us see the plane.
yes, my plate is, my lord, is vernacular, sir.
Huh?
It is in vernacular, my lord.
You have got some English. But it can.
Small. Hey, read,
Yes.
my lord, hey, read,
Which one?
plate, my lord.
Huh?
Plate, my lord.
Plane. Read it.
My lord, from the paragraph I am reading, my lord, paragraph number 1, তফসিল বর্ণিত বিবাদীগণের মালিক সত্ত্ব আর দখল করা তা বাদীর নিকট বিক্রি করার জন্য মূল্য 1,20,000 টাকা ক্রমে 7/2/2003 তারিখে নগদ 1,00,000 টাকা গ্রহণ গ্রহণে কয়নানামা মূল্যে অঙ্কা 6/8/2008 তারিখে মধ্যে কোনো দিন বাকি 20,000 টাকা 20,020 টাকা সামজাইয়া দিলে তারা তফসিল ভূমিকে কপলা সম্পাদন করে রেজিস্ট্রি করে দিবে। বাদী বিবাদীর পক্ষে বারবার নগদ তাকদা করিয়া কপলা পাওয়ার জন্য অবশ্যই এনওসি বাহির করার দরখাস্ত করাইয়া না পারিয়া গত 28/4/2004 তারিখে বিবাদী পক্ষকে রেজিস্ট্রি ডাকযোগে নিযুক্তি অ্যাডভোকেট মারামত নোটিশ 10/5 তারিখ ইংরেজি তারিখের মধ্যে এনওসি বাহির করার জন্য দিন ধার্য ক্রমে বাদীকে
Their statement is there and to receive the remaining 20,000.
that is the thing, but this is
No,
important.
no. That statement is that and to receive the 20,000.
Yes.
Means he is ready and willing as regards the 20,000. Because 20,000 he was remain.
Yes.
Now let's see what is your evidence. What is the stand your evidence? Paragraph 2.
May I read?
Their case was there was no agreement.
Huh?
There was no agreement. Their case was
There was no agreement.
no.
We denied. We denied, but only thing.
Any
minor.
agreement.
Yes.
So he had issued a legal notice
Yes.
stating that kindly receive this 20,000 and do it. Now what does the learned trial court?
Yes, planet and trial court pilot. Issue number 3, but.
Hmm?
Pilot page, I know memo page 14, pilot, issue number 3, pilot. Issue number 3,
Page 9.
yes,
page
page 9 the issues, pilot.
Page 9 is the
Issues, pilot. The
whether
additional
the
issue must.
defendant executed the bindama in favor of the plaintiff to sell the suitable rent and was ready to perform 2 and 3 is binding upon the defendant for 6 to 32 of the binding. Did you file an FIR
Yes, but.
for losing the AR?
Yes.
Did you produce the FIR?
So, but that was the final report has been
No,
submitted.
no. Did you file an FIR and produce the FIR before the court?
No. No, man, only the complaint, yes, the final report has been submitted in respect of this. I did not.
Defendant, you did not give any exhibit.
Yes.
There is nothing that you have given a reply to that notice. You have received the notice, legal notice. What is there? The legal notice, the question is already there.
Yes.
Then, title appeal. What is wrong?
My lord, the time and notice given and the date of registration of what he said, my lord, to come to court, my lord, within a period of 13 days is possible.
What?
My lord, kindly see, my lord, what is this plain, what is said, and in the finding of the court also, it has come, my lord. And the, my lord, he has issued, my lord, legal notice on 28/4/2004. Yeah. To register for asking to obtain NOC. On or before 10/5/2004, within a span of 13 days, and remain present on 11/5/2004. After 1 day, before the deed writer, Babul goes and execute the registered check. My lord, this is not impractical, man.
We are not on impracticable. Impracticability is for rich petition.
Within a
Mhm.
on record, man. It is there, man.
No, we are not concerned with what it is.
The
The
way
fact
he-
that there is a finding of fact arrived there, that there was a binder, which you did.
I did that.
The fact that there is a ready, the trial court had held that it was ready to perform, there was readiness, and the notice which was issued categorically had stated, which was proved, stated that he is willing and you have received the notice.
Yes.
The only amount remaining was 20,000, which he was willing. So ready and willingness is there. Then cheating is there, proof is there. What else is required? You wanted that the issues should have been framed and that it should have been held as points of determination. Order 41, Rule
No, I don't
31.
know, only one thing so far as we did not produce the notice, reply of the notice, but we have given the reply that is admitted by the, that is mentioned in the plaintiff. We have replied.
Understood. You replied. That is another aspect. I'm not concerned with the reply. The fact that you have not given that. See, how do you take care of section 91 of the Appellate? It categorically says that if it is a document, it has to produce the document, nothing else can be read into 92 is a bar. So, what do you mean? What is order 41, Rule 31?
My lord, so far as the April Court judgment, my lord, issues were not, that's point one.
What were the issues?
Regarding the discussion
court had
regarding the
duly
ready and willingness.
No,
and
the court has given it. See,
It is
how do you
given.
take care of that? The issues have been duly taken note of by the first appellate court.
And per page 20 more specific. Let's say point of frame. Page
Huh?
20. Page 20, my lord. That was the only issue. Page 20, my lord, down below para 7.
There's some out that the names of the defendant before were struck off and the order did and consequently the statement was accepted. In fact, the
Para 7, my lord.
paid by the court came that you it appears the plaintiff has accepted
Everything can.
very neat piece of it. Right, okay. Yes, it says na, register the sale deed in favor of A1 and would receive the 20,000 at the time to registration as well. So the ready and willing is there. Nothing is there.
One more point, Director.
Yes,
One more point.
yes,
Suppose,
Mr.
my lord, it is good for a specific purpose. Suppose I don't protest. Then it's the duty of the plaintiff to go through his process properly. That he is ready and willing and he has properly pleaded and he has to prove all these things properly. But those things is necessary.
He has stated in his pleading that look here, I have issued the notice. 7/2/2004 is that no agreement. On so and so, we have issued a notice asking him to do so on such and such and receive the amount of 20,000. This pleading is a pleading that he is ready to perform. Now you require the proof. Proof is that particular document which is produced. The ready and willingness, readiness and willingness is proof taken in C.
And in his cross-examination also,
Huh?
in his cross-examination also, could not specifically support his
Who did not support?
that claim.
He did not support him.
He is supported, but not as stated in the claim. That is,
He has
that
not
way-
stated anything in plain. He said more things in his cross. You have taken out more things in the cross. Unnecessary. Problem arises there.
And the decree has been executed already, my lord.
Mr. Huh?
So the process of the court already executed.
that we are not aware.
Anyway,
No, I
the-
said
Mr. Roy, what problems happens in the trial court is this. Them. I've seen it many times. The lawyer wants to show to his client who is present. Because you see, in the trial court, parties are pressed with the litigation. So the enemy between them is much stronger,
that's right.
which is there in the second case. So in the trial court, that person really likes that this plaintiff or the defendant, whoever is the witness, is dealt with. Because what happens in the pro, he can't say anything against the lawyer. And if he says the court is defendant, you can talk to your lawyer, talk to this lawyer like you are to answer whatever. So this is the thing which is a great source of happiness for the client.
That's right.
And in order to do that, what happens is the lawyer also outplays it and keeps on asking to play to the gallery. And there, many of the cases get.
That's why
I would not name, there are many lawyers out there.
No.
They do that. And after asking the question, if he thought, then the court says something, he immediately turns back and makes a smile to his client. The client is more than happy to to get a decree. Okay, enough. This is an appeal under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 24/3/2009, passed entitled Appeal number 22/2007, whereby the judgment and decree passed by the learned trial court dated 29/9/2007, entitled suit number 106/06 102/06 by the Court of the Civil Judge Junior Division number 1, Hailakandi, was set aside, was reversed. Was
No,
affirmed. Was affirmed.
concurrent.
Agotu Lukunte, first appellate. Civil judge, what is his name? Civil judge Hailakandi, first appellate court. Itu trial court of law. It appears from the reports that this court, by an order dated 4/10/2010, had admitted the appeal by formulating a substantial question of law. The said substantial question of law is reproduced hereinunder. In addition to that, on 7/12/2023, this court have framed an additional substantial question of law, which is also reproduced hereunder. The question arises that in the instant case as to whether the said substantial questions of law so formulated by this court are involved in the instant appeal. For the said purpose, this court finds it relevant to take note of the brief facts leading to the filing of the instant appeal.
Regarding the reply of the notice, the plaintiff made exhibit.
Huh?
Our reply has been made exhibit by the plaintiff.
Where?
There is exhibit 5. Reply of the notice dated 10/5.
What did you say?
How we denied
Execution of the
execution of the
Agreement.
Panama we
agreement. You have denied. The facts, the respondent herein as plaintiff had instituted a suit seeking specific performance Where is the plaint again? I don't find it.
Plaint is not annexed to the receipt.
Page 9.
or we can cover
No, it's okay. Wait. I saw it somewhere, na? And again, the respondent herein as plaintiff had instituted a suit being title suit number 102/2004, 406, 4.
4, my lord, 2004.
Huh?
It was, I mean, originally it was number 27 of 2004, later renumbered as
Was
102
filed
of
the suit,
2006.
which was registered and numbered as title suit number
27 of 2004,
27/2004
Later
before the court
renumbered.
of
in the court of my lord, senior division,
civil judge senior division Hailakandi,
Lord,
Pushkar, seeking specific performance of an agreement dated 7/2/2003, 3 or 4, 7/3/2004,
exhibit 1, 7, 2003. my lord.
3,
3.
7/3/2003,
7, 2, 2000.
7/2/2003. For the plain somewhere, this. Oh yes, got it, got it. 7/3/2003,
7,
7/2/2003. and other consequential reliefs as mandated under law. It was the case of the plaintiff that the defendant had entered into the agreement dated 7/2/2003 for sale of the footland at a total consideration of rupees 1,20,000, of which an amount of rupees 1 lakh was paid at the time of entering into the agreement, and the remaining 20,000 was to be paid at the time of execution of the registered deed of sale. It was further mentioned that the deed of sale should be executed within 6/8/2004. The plaintiff thereupon insisted the defendants to obtain the necessary no objection certificate, and thereupon and further noticing that the defendants were not taking appropriate steps, a legal notice was issued on 28/4/2004 directing the asking the defendants to obtain the no objection certificate within 10/5/2004 and thereupon appear before the office of the sub-register Hailakandi along with the no objection certificate on 11/5/2004 at 10 hours, and to appear before one Sri Babul Ghosh, the deed writer, in the sub-register's office and to receive the remaining 20,000 rupees and execute and register the deed of sale. And also to hand over the possession of the suit land on the next day. The defendants did not obtain the no objection certificate, but on the other hand, through their counsel, one Mr. Nurul Haq Majumdar sent a reply dated 10/5/2004 stating that they did not execute the agreement, which was fraudulent. It is under such circumstances that suit was filed seeking specific performance of the agreement dated 7/2/2003 and for other consequential reliefs. The defendant thereupon filed a written statement denying that any agreement dated 7/2/2003 was executed by and between the plaintiff and the defendants. It was alleged that the agreement dated 7/2/2003 was prepared fraudulently, for which the question of granting specific performance does not arise. On the basis of the above, the learned trial court framed as many as. Four issues. Initially. And thereupon, on 19/11/2005, framed another issue, additional issue, as to whether the binumber dated 7/2/2003 was binding upon the defendant numbers 4 to 6. However, subsequent thereto, the defendant number 4 to 6 were struck off. And accordingly, the additional issue, they so framed on 19/11/2005, lost its force. The issue number 2 and 3 are very pertinent for the purpose of the instant dispute, instant appeal. Inasmuch as the issue number 1, 2 relates to as to whether the defendants executed the binumber dated 7/2/2003 in favor of the plaintiff to sell the suit land on receiving the advance of rupees 1 lakh. And the issue number 3 related as to whether the plaintiff was ready to perform his part of the contract. The learned trial court decreed the suit in favor of the plaintiff by the judgment and decree dated 27/9/2007. In doing so, the issue number 2 was decided on the basis of the materials on record, and the learned trial court came to a categorical finding that the agreement dated 7/2/2003 was duly executed by the defendants. As regards the issue number 3, the learned trial court also came to a finding that the plaintiff was ready and willing to perform his part of the contract. Being agreed, the appeal was filed by the by the defendants before the learned first appellate court, which was registered and numbered as title appeal number 22/07. The said appeal was dismissed by the judgment and decree dated 24/3/2009, and it is against the dismissal of the said appeal the instant second appeal has been filed. I have heard Mr. A.U. Chaudhary, the learned counsel, appearing on behalf of the appellant, and Mr. P.K. Roy, the learned senior counsel, assisted by Mr. S.K. Chakravarti on behalf of the respondents. Let me give it next. You have gone through that requisition judgment.
Yes, my lord. That was a very.
There is no other way I
No,
can
no,
do
seriously,
anything.
Given that I am so happy, my lord. It's a good judgment.
It may only do one thing, means for future it may be of
Lordship,
some help.
exactly. Lord.
But there could otherwise, I think it's a very sorry state of affairs because of that there was a delay.
Lordship.
If the
And
matter
your
would have
lordship has
been
referred to
done.
that Supreme Court, my lord, that fraud on the that is a good judgment, my lord.
Yeah.
Good.
You referred to H.D. Vora.
Yes, sir, that fraud on power. my lord.
Yes. And then I got out that
Lordship, I have
Grahak
seen-
Manch
Lordship, I
Sanstha,
have seen that.
where because H.D. Vora said two aspects.
Lordship.
One was the aspect pertaining to if it is for permanent requirement,
Lordship.
then you cannot requisition.
That's right.
The Supreme Court, however, said that not necessary. But later on, another 3 judges bench, Rajendra Kumar, said that then also you have to explain why it is required
Exactly.
and not what now. Then the matter again came up before another Kolkata Municipal Authority, and then the matter came up recent B.V. Ravichandra, which is the most relevant thing, wherein it's Justice, I think, Ravindra Bhatt was there, wherein he brings in the concept of lawlessness, violation of Article 300A, and also one very pertinent that if the court does not do anything, it would be condoning the lawlessness.
Exactly.
But this is a very important aspect.
It's a good judgment for all times to come. My lord. For all times to come, my lord, it's a good judgment.
Yeah. I think the and because there has to be.
The law.
In fact, the initially, as per the constitution bench, initially you can requisition. And that why it is to be required? Because acquiring may take some time.
Law.
So they can go for a
That's fine.
requisition, and thereafter you have to explain why you want to keep it for requisition. And not why couldn't now you go for acquisition.
The 64 Act itself provided for provision of acquisition. It is for this purpose only. You need it.
Therefore, I did not mention one thing, under what provision you are going for requisition, because why I did not say it, on the face of it, the order of 22/10/1986 did not say that it was a requisition under the 64 Act. It could have been under 35. I've added it as your submission also. It
Lot.
could have been under section 35 of the 1894, which only permits for 3 years.
3 years. That's right. Exactly.
And then 35(3) categorically also mentions a reference. The reference is given under 35. So,
Different.
As far as item number 7 is concerned, on the last occasion there was a misunderstanding regarding the paper book. It was the record that the paper book from record. But in my thought, there was an file which does not contain all the paper. I am very careful that my recorded. If there is a paper, the LCR may not be called for. Now, it is not the paper book actually, my lord, it is the IA. So entire records are not before the court.
which one?
Item
number?
7.
Morera Appellate. Then
My lord, either your lordship will call for the report or give me an opportunity to give the my lord paper.
it has been admitted
It is
by full framing substantial question of law. Then we have to call for a record. It is so. It doesn't happen. But this will only.
of the paper.
But
Because the paper will be more comprehensive to my lord, the lordship and the paper.
because it will only, if we call for a record, it will only delay. Because
Yes.
RERA needs to be done as soon as possible.
That's why my lord, I request that. I'll prepare. Okay, thank you.
Item number 76. On 3/4/2024, this court had recorded that the appellant had already prepared a paper book, which is a part of the record. The said submission was being made on the basis of the contents of the interlocutory application. However, during the course when the matter was taken up, it seemed that the entire material which were before the learned first appellate tribunal is not before the court. Mr. Endeka, the learned counsel appearing on behalf of the respondent appellant, submits that he may be given the liberty to prepare the paper book and file it before this court. List on when, how much time? List the matter again on 29th, 30 May, 30/5/2024. In the meantime, the paper book we prepared and filed by 29th of May with copies being furnished to the learned counsel appearing on behalf of the respondent. Clear? I've heard the learned counsel. the question of law, the substantial question of law, which was formulated on 4/10/2010, as to whether the first appellate court was justified in upholding the judgment and decree passed by the learned trial court without recording any finding relating to readiness and willingness of the plaintiff to execute his part of the contract, in the opinion of this court, is not involved in the instant appeal, taking into account that the learned first appellate court, while dealing with, in paragraph number 7, have duly, paragraph number 7 and paragraph number 9 have duly taken note of the readiness and willingness of the plaintiff to perform his part of the contract. In the backdrop of, in that view of the matter, the substantial question of law so formulated on 4/10/2010 is therefore not involved in the instant appeal. The additional substantial question of law so formulated on 7/12/2023 as to whether the judgment of the appellate court is bad in law for non-compliance with the provisions of Order 41, Rule 31 of the Code of Civil Procedure. This court finds it relevant to observe that the learned first appellate court have duly taken in note of the grounds of objection and have assigned reasons for which this court is of the opinion that the same is in accordance with the provisions of Order 41, Rule 31 of the Code. Further to that, the learned first appellate court, while confirming the judgment of the learned trial court, have also duly applied its mind and assigned reasons. Consequently, the said additional substantial question of law formulated on 7/12/2023 is not involved in the instant appeal. In that view of the matter, the instant appeal, being devoid of any substantial question of law, stands dismissed with cost quantified at rupees 25,000. How much? Cost quantified at rupees? How much? 4 per. Then 11,000. Cost quantified at rupees 11,000 for the instant proceeding. And further, the respondent would be entitled to cost throughout the proceedings. Appeals return debts.
Already been executed. That is
You see, I have given it. Whether he goes for execution for that cost or not, I don't know. Getting. Anyway. Yes, Mr. Storm.
Lordship.
What has happened? Has the suit been executed? Decree?
Execution, in execution, I have filed a
No, all these matters are going on, but this order was passed as on
There was a stay, Lord.
22.
Position has not given. Position is not given, Lordship, till date.
Not given, na? Yes, which judgment? Which paragraph?
Lordship, Brahmadev Chaudhary,
Hmm.
1997, 694, Your Lordship. Paragraph 8, Your Lordship.
Paragraph?
8, Your Lordship. Still discussion is there, and it's page number 702, last line, Your Lordship.
This is what has been stated in silver line, no?
It is a silver line. Thereafter, I have submitted to Lordship next one.
Silver
1998.
1998.
Silver line.
Brahmadev Chaudhary, it is Lordship.
Actually, silver line is
Brahmadev Chaudhary relied in the silver line judgment.
in fact, earlier, prior to 1976, a suit was mandated.
Yes, that was there. That was there.
Now it is not, in view of the amendment brought in.
Yes.
In one judgment, I have done it, forgot. Silver line gives the, I think silver line is, yes. Paragraph 9. At the outset, we may observe that it is difficult to agree with how the resistance made by a third party to a deal cannot be gone into influence. Those rules were intended to deal with the safety sort of resistance or demand that when the holder of a degree is in possession of so it makes it incumbent on her to proceed such a complaint in accordance with the it is silver line is a case where can a person come, whether any person would come within the ambit of can file an application.
Application order 21 rule 19.
And here it explained, Srinath,
Srinath is explaining.
Srinath, it is explained prior to 76 and after 70. Now, tell me, you were not a party to the suit.
Lord, I was not a party.
You were not a party to the better, but you were in possession
Lord.
of the suit land,
Yes, Lord.
as could be seen from the report given by the Nazir at the time of execution. Isn't it?
Yes.
This is apparent from the materials
Yes.
on record. So under such circumstances, if you were in possession of that, you had a right to file. The court, therefore, was required to look into it. Did you have an independent title? Rehearse the judgment depth.
Yes.
If you have an independent title, then it has to be decided as if like a suit and pass a decree.
Lord.
Isn't that, madam?
Yes, Lordship. In fact, Lordship, judgment debtor Lordship, in a written statement, he stated that he was in position. Lordship.
Maybe, but
Now,
at that point of time, there was somebody else. Unless you prove it that he has done or he is doing it having no title or anything, in this case now he has to.
exactly his position, Lordship, and right title
It
he
is
has.
the other way. He has to prove his right title in interest over that, and then the court will.
Intake Lordship 2021 one judgment is there in this line, Lordship. No separate suit line.
Huh?
No separate suit is
Yeah.
required. 21 judgment.
In fact, there's one judgment that delivered. Yes. But one thing one has to agree, means one has to take note of that it would not exactly be like a suit.
Yes, that is there. Lord.
Perhaps evidence is also not.
The evidence required. He has to show that. He
Yes.
has to be given an opportunity to give evidence because it will be a decree against
Yes,
him
yes.
also.
Another judgment in 23 also, Lordship. Same time. 2023.
His judgment in Samsher Singh makes it very clear. The beautiful judgment of the Supreme Court. On 2019-17 SCC 279. It is why it is now how it is.
Samsung been discussed in this judgment, Lordship 2023 judgment.
Hmm?
It has now handed over 2023 one judgment. Here, Lordship, Samsung being discussed. Paragraph 13, 15.
In view of the welfare of the state, it's the duty of the executive to issue warrant of possession by effecting of them.
Paragraph 13, Lordship. Samsung. Paragraph 13.
That's 15. This is an appeal under section 100 against the judgment and decree dated 9/12/2022 passed in Miss Appeal number 02/2021 by the Court of the Learned Civil Judge Lakhimpur, not Lakhimpur, whereby the appeal filed against the rejection of an application under Order 21, Rule 97/99 and 101 of the Code of Civil Procedure 1908. For short, the code was affirmed. This code, by an order dated 8/5/2024, had admitted the said appeal by formulating a substantial question of law, which reads as under 8/5 order. The question therefore arises in the instant appeal as to whether the learned executing court as well as the first appellate court were justified in dismissing the application and relegating the appellant to file a separate suit. Taking into account the short question, this court have therefore taken up the matter today, as any delay in disposal of the instant proceeding would not either be in the interest of the judgment decree holder as well as also the appellate. I've heard Mr. A.R. Shawn, the learned counsel, appearing on behalf of the appellant, as well as Ms. P. Bhattacharjee, the learned counsel, appearing on behalf of the respondents. The Supreme Court, in the case of Pramod Dev Chaudhary versus Rishikesh Prasad Jaiswal and another, reported in 1997 PSCC 694, called out as to what a conjoint reading of Order 21, Rule 97, 98, 99, and 101 of the Code projects. Paragraph 8 and 9 of the said judgment, being relevant, is reproduced hereunder. From a perusal of the said judgment, above quoted paragraphs of the said judgment, it would be seen that when an application under Order 21, Rule 97 is being filed, the executing court has been endowed with the power to pass appropriate orders after adjudicating upon the controversy between the parties as enjoined by Order 21, Rule 97, Sub-Rule 2, read with Order 21, Rule 98. In the case of Silverline Forum Private Limited versus Rajiv Trust and another, reported in 1998 PSCC 723, It was observed that Rule 97 to 106 in Order 21 of the Court are subsumed under the caption inverted comma resistance to delivery of possession to decree holder or purchaser inverted comma close. Those rules are intended to deal with every sort of resistance or obstruction offered by any person. It was observed that a third party to a decree who offers resistance would fall within the ambit of Rule 101 if an adjudication is warranted as a consequence of the resistance or obstruction made by him to the execution of the decree. It is also apposite herein to take note of the observations made to the effect that Rule 102 of Order 21 prohibits the resistance made by a transferee pendant light of a judgment letter. Paragraph 12 of the said judgment gives a clear picture as to what the term words inverted comma all questions arising between the parties to a proceeding on an application under Rule 97 inverted comma 2 would envelop. It was observed that the court is not obliged to determine a question merely because the register raised it. And the questions which the executing court is obliged to determine under Rule 101 must possess two adjuncts, A-D-J-U-N-C. First, such questions should be legally arisen between the parties. And second, the question must be relevant for consideration and determination between the parties. That is, if, for example, if the obstructor admits that he is a transferee pendant light, it is not necessary to determine a question raised by him that he was unaware of the litigation when he purchased the property. Similarly, a third party who questions the validity of a transfer made by a decree holder to an assignee cannot claim that the question regarding its validity should be decided during execution proceeding. It is therefore necessary that a question raised by the register or the obstructor must legally arise between him and the decree holder. This court further finds it very pertinent to take note of another judgment of the Supreme Court in the case of Samsay Singh and another versus Lieutenant Colonel Nahar Singh, dead, two legal representatives and others, reported in 2019-17 SCC 279, wherein the Supreme Court observed that post 1976 amendment the objector if being removed from possession and seeking to be put back into possession has not only to prove that he is in bona fide possession, rather he has to prove his right, title, or interest in the property. It was also observed that the objector cannot claim recovery of possession or to remain in possession merely on showing that he was in possession of the property, but he has his right, he has to also prove his right, title, or interest in the property. The Supreme Court further observed in the said judgment that the use of the words inverted comma all questions bracket, including the questions relating to right, title, or interest in the property bracket close, arising between the parties to a proceeding on an application under Rule 97 or Rule 99 inverted comma has to be given meaning and full play. And in view of Rule 103 of Order 21, any adjudication made under Rule 101 shall have the same force and be subject to the same conditions as to an appeal or otherwise, as if it was a decree. This court further finds it relevant to take note of the judgment of the Supreme Court in the case of Bangalore Development Authority versus N. Nanjappa and another reported in 2021 SCC Online SC 1179. Wherein the Supreme Court at paragraph number 15 observe that as per order dated 20 order as per order 21 rule 101 CPC of the court, all questions including questions relating to right title or interest in the property arising between the parties to a proceeding on an application under order 21 rule 97 or rule 99 and relevant to the adjudication of the application shall be determined by the court dealing with the application. For that, a separate suit is not required to be filed. In the backdrop of the above propositions of law, if this court takes note of the orders being passed by the learned executing court as well as the first appellate court, it would be seen that both the courts below did not decide as to whether the plaintiff, the appellant hearing, who was the objector, had been able to prove his right title or interest over the suit property. Rather, relegated the appellant to file a separate suit. The same, in the opinion of this court, is completely contrary to the provisions of Order 21, Rule 97, 99, and 101 of the court, as well as the well-settled principles of law. Accordingly, this court therefore sets aside the judgment and decree dated 9/12/2022, passed in Miss Appeal number 02/2021, and directs the learned executing court to decide the application filed by the appellant under Order 21, Rule 97, 99, which have been registered and numbered as Miss Case number Miss A Case number 16/2020, within the contours of the jurisdiction under Order 21, Rule 97 to 106. Taking into account that both the parties are duly represented, the parties are directed to appear before the learned executing court on 3rd of June 3rd of June. Full stop. The learned executing court, on appearance of the parties, shall dispose of the suit, the said application, in accordance with the settled principles of law as already mentioned here in the above. With the above, the instant appeal stands allowed. Full stop. In the premises, this court is not inclined to impose any cost.
Okay.
I stand.
Acknowledge.
But substantial question of law, which the parent is not actually involved in.
Yes.
Lord, a 6 feet path was given in the cell deed. Now he wanted, he'll make some construction, my lord. So he filed a suit. In the suit, my lord, he paid that he has the right over that land for incoming and outgoing. And the construction is illegal. And trial court, my lord, if your losses, see page 14.
It's a
that is-
concurrent.
My lord?
The concurrent.
Page 14, my lord, that's the order of the trial court. And that is upheld by the. So this issue, partially substitution law is not there. They have not given the title, my lord, only right over a land piece. And construction has been declared in there. Page 45.
Problem is the appellant may have not known that their counsel have expired.
But 4 persons are there, my lord. 4 advocates are there. Not
Their names have been shown.
Yes, yes, my lord. H. Hawk, S. J. Y. Jimran.
Okay. None appears on behalf of the appellant on call when the matter is taken up for hearing. Mr. J. N. Sahewala, the learned senior counsel, assisted by Ms. P. Bhattacharya. K. Bhattacharya, appears on behalf of the respondent. Taking into account that the appellant is not represented, the instant appeal stands dismissed for non-prosecution for default.
Interim order passed.
Interim order passed if any stands vacated. The registry shall return the LCR after 3 months from the date of the instant order. Yes, any better substantial question? You don't have a case, Mr. Chaudhary. I've read the judgment of the first appellate court. Properly written.
The
The plaintiff was the identifier.
that is a wrong term, my lord. That finding is perverse, my lord. That is perhaps the only
How?
one.
How do you
I-
say it to be perverse?
My lord, I'll show from the evidence, your lordship.
Yes, what?
My lord, if your lordship kindly comes to the evidence,
Hmm.
The evidence of the my lord, CW1, the plaintiff.
Hmm. Yes.
There, my lord, there were suggestions made.
Hmm.
Suggestions, your lordship is fine. And my lord,
Now, what does he say about the limitation?
limitation, my lord, that is-
You say that you knew about those deeds.
No, my lord, that that your lordship is also a part of this suggestion, and thereafter, when my lord you say that you know now, because you know now that it the register, he said yes, but when he doesn't say that, my lord, that is important.
Let's see that portion.
Your lordship may kindly come to, I have designated the evidence.
Hmm.
Page
15.
Page 14, 15. But before that, my lord, your lordship may kindly come to page 8, where he has stated, my lord,
Hmm.
that he has not, he is not a my lord identified. Page 8, your lordship will find, paragraph 11. Upward, এতে বিবাদীগণে উচ্চ তথাকথিত জাল তিনিখন বিক্রি দলিল বলে গুচুরীয় 3 বিঘা মাটি বারে বারে দাবি করে। Then subtracting-মূলক and জালিয়াতি, he said in the next page, third sentence, your lordship will find. বিবাদীয়ে গুচৰীয় জাল দলিলত মোক চিনাক্তকাৰী হিচাপে দেখুৱাইছে যদিও মই গুচৰীয় জাল দলিলসমূহৰ চিনাক্তকাৰী নহয়। বিবাদীগণে ইচ্ছাকৃতভাৱে জালিয়াতি কৰি মোক চিনাক্তকাৰী সজাই ৰাখিছে। Then your lordship may come to the cross. That was the matter in case. Cross at page 14. The portion, my lord, marked with star.
Yes.
Yes, these are all suggestions. এইটো সত্য নহয় যে 8/11/95 তাৰিখে মোৰ পিতাই ইমান ৰেজিষ্টাৰ দলিল যোগে ডাগৰ 1 বিঘা মাটি দলিলত চহী কৰে। এইটো সত্য নহয় যে 20/3/85 তাৰিখে মোৰ পিতাৰ জবান আলীয়ে 1 নম্বৰ বিবাদী নুৰ ইছলামক মোৰ পত্ৰাৰ ইমান নম্বৰ দলিলে বিক্ৰী সংস্থান কৰে আৰু সেই দলিলত চিনাক্তকৰণৰ বাবে মই চহী কৰোঁ। So that was my lord suggestion he has denied. Then my lord, next page your lordship will find there, my lord, the confusion perhaps of the appellate authority, appellate court arose somehow in the middle that mark মই 1984 আৰু 94 চনৰ দলিল কৰা কথা মই জানো। So my lord, this has been taken as if my lord he knew at that point of time. Now it has been exhibited, therefore he knows. When he knew about it, that is not the question. So this is where, my lord, my submission is that, my lord, the appellate court committed the mistake in taking it to the admit. Because all these are suggestions to him, and he was denying all these suggestions.
Then read the next line. এইটো সত্য নহয়।
এইটো সত্য নহয় যে দলিল বিলাকৰ
সাক্ষী
সহিবুট perhaps, because that was my lord some impression on it. মোৰ কোনো উপায় দেখা but these are all suggestions that denied. All suggestions start, my lord, from page 13. These are all suggestions.
No, it was your suit.
That is-
How did you prove the fraud? You only say that it was not a sale made by my father.
So not made by my father, and my lord, I was not the identity.
How did you prove it that it is not? It is your burden. 101.
That is right. But at the same time, my lord, there is evidence on record made by the other side, my lord. They
No,
also,
other side, no, let us not consider other side. Burden is on you.
but you see, my lord, the evidence was there to be put.
No, where is the evidence that you have discharged the burden that these signatures were not mine or my father were not, or the thumb impressions were not there? You could have very well asked the thumb impression for other documents to be looked into by
That
fingerprint.
your lordship is correct, my lord. Besides this, my statement that my father did not do it, and that, my lord, I was not the identifier. Beyond that, my lord, that's it. That is true. But then, my lord, the doubt arose before the trial court that, my lord, why for so many years you did not come to community? Because after death, the my lord, father, the only my lord people.
Because your thing is that only after the death of the father they manufactured that document. But from the material, because your allegation is that after the death of the father, they made the document.
And that, my lord, strictly speaking, my lord, that evidence has not been verified. That is right. In my prayer,
How do you prove 101? How do you take care of 101?
my lord,
Others is okay. Let us assume the trial court was wrong in taking that note into account or that fee. But would that be a substantial question of law? If
However,
the otherwise you have failed to prove,
yes, my
it
lord,
would have
your-
the
your- your-
substantial question of laws would be such which would otherwise change the nature of the proof entirely.
my lord, my only submission is that, my lord, that finding of the protected court, that is my lord.
No, but let us assume that he did not accept. Let's assume it. It would amount to appreciating, but let us go to that extent for this.
Then, my
But
the
then,
burden,
how do you take care of 101?
my lord, yes, my lord, the burden has not been fixed. Then I agree.
Without that, cannot be a substantial.
I pray your logic.
Huh?
Your logic. The other side, but other side is that not.
I don't issue notice. In my opinion, notice, issuance of notice to the respondent amounts to means the court admitting that he doesn't know anything about Section 100. In fact,
my
Mr.
lord,
Chaudhary,
beyond this, perhaps, my lord, I cannot agree.
yesterday I got one matter of 2004. Order was passed was in 2024. I have taken it at the stage of Order 41, Rule 2011. After 20 years, it was a case by where first day the order was passed not in the injunction application or stay application. Issue notice pending consideration of the interim prayer. Status quo be maintained in respect to the suit property, meaning thereby an injunction is being granted. Appeal not admitted, because the jurisdiction this court will get only on that. And then the matter was dismissed for default for on 8 occasions. It was last restored, but then yesterday it came up for restoration application. I said one has to finish everything. So what I did is I restored, condoned the delay, restored it, then dismissed. It has to end some. But here the problem arises there. That is why I gave you another chance.
I cannot argue before lordship.
Eh?
I cannot argue unnecessarily. These are the points, my lord.
But you have to prove. How do you prove it?
Case was not properly conducted. So that's it.
Okay, I give you still another time. Think about whether you can make out some case by which I can frame an issue and then remit it back for remand. That is the only way out you have. Otherwise, you don't have anything.
I'll be good.
But then also you have to show me. Or I can do one favor to you. Let me fix it on 5th of June. I am not here. Somebody may issue. The request of the learned counsel, the appellate matter, and adjourn to be discussed again on 5th of June. Mr.
My lord, a taxi service may also start. A taxi service may also start.
Mr. M. Khan, the learned counsel appearing on behalf of the applicant, submits that steps have been taken today to list the matter after completion of service. Justice service, why will I give you first day? Tell me. You have been asked to take steps on 7 to 2024, and today I have asked you. Can't help it like that. Congratulations.
May it be, your lord.
Hmm.
Lord, this is a second appeal, your lord. You could find my lord, it is the judgment and degree passed by the learned law appellate, my lord, reversing the judgment passed by the learned trial court, and partially denying the suit, your lord, filed by the daughter. And the learned law appellate court, my lord, accordingly to the suit filed by the president and its daughter, your lord. That is the case, your lord. Now, here is the case, your lord. You could find, my lord, the plaintiff, they filed the suit, my lord, for declaration of their right title in interest, your lord. You could find, my lord, at page 62, my right title in interest over, my lord, A, B, C, and D scheduled land.
Where is the plaint?
Plaint, your lord, you could find, my lord, at page, your lordship, it is, my lord, plaint, my lord, 57. 57. And I am, my lord, taking your lordship, my lord, page.
You are the plaintiff.
We are the defendant.
Suit for declaration of title of the plaintiff in the suit plan. Declaration that the defendant has no title over any part of the suit plan. Correction of the revenue record. Declaration that defendants are trespassers in the suit land, and recovery of past possession of A3 by 20. Okay, then.
So these are the, my lord, prayers made by the plaintiff, your lordship.
What is your
And
case?
my lord, they said, my lord,
The plaintiff claims his right on the basis of what?
basis of, my lord, they say they purchased this schedule B, C, and D, my lord,
And possessors
by
of
an, my
land
lord,
therein
oral
dwell
deed of sale, your lord. That is their case, your lord. Now, planet Munsif, my lord, in, my lord, deciding the suit, my lord, in deciding issue number 3 has held, my lord, that the plaintiff has right title and interest, your lord. You may kindly see page 14, your lord. That the plaintiff, my lord, respondent, they have right title and interest over, my lord, schedule A land. Schedule A land, my lord, is a part of schedule A land. Now, we may not have much, my lord, objection on that, your lordship, because they say by filing, my lord, exhibit 1, they purchase the land. The predecessors of the plaintiff purchase the land from one Orendranath Adhikari, my lord, who was the patadar, my lord, annual patadar of this land. So far as this, my lord, so far as they are, my lord, claim over, my lord, schedule A1 is concerned, my lord, we do not have any much objection. Our objection is with regard to, my lord, schedule B, C, and D. Now, schedule B, C, and D land, my lord, these are separate lands, your lord. If your lordship goes into Patta and dark and all these things, my lord, your lordship will find that the lands described in schedule B, C, and D, my lord, these are not the part of schedule A land here. Now, case of the plaintiff, my lord, these lands also belong to Harindranath Depoticary, and, my lord, the predecessors of the plaintiff, my lord, purchased the land described in B, C, and D by an, my lord, oral deed of sale, your lord. That is their case, your lord. Fine. At the plaint, my lord. So, my lord, I think, my lord, this is not, my lord, sustainable, my lord, when, my lord, your lordship will find, my lord, at page 59.
What is your title over there?
My title is that, my lord, this land, my lord, it was originally belongs to Harindranath, my lord. He left the place and we are in possession.
So?
We are in possession, and ultimately, my lord, government, finding on, my lord, finding ourselves in possession, and on receipt of premium, my lord, had settled this land and granted patta to us means our predecessors, my lord, in the year during the year 1958-65, my lord. Exhibit K. And this
Exhibit
Exhibit K. Lord.
K.
And these Exhibit K, my lord, was neither challenged in the plain, nor it was taken into consideration by the learned appellate. Now, my lord, if
Where have you mentioned about Exhibit K?
exhibit
Paragraph of your plain written statement.
written statement, my lord. Who said, my
Actual
lord, that-
page 68. The actual fact of the suit is that the suit land was sued in the name of Harendranath Deva Adhikari, but he did not came into the possession of the suit land. He transferred the
my
suit
lord,
land
our case, your lord,
possession of that to the defendant's father about 40 years ago, and from where very childhood the defendant knew that the land is
paragraph
their
7,
own
your
and they
lord.
were residing on so and so, measuring Iman of tag number and other tags in their the original Patta Dahiya were resided in separate villages. The suit then was mediated in the name of defendants in 1990 by reference case number passed by an order by so and so of land so and so. The invalid tag number so and so the land was made in the name of an entity
Paragraph
transferred
7
the
of our
land to the
written
possession
your lord.
of the defendant about
Lord,
40
we have
years
stated, my lord,
before
that
filling of the
this land
invalid tag
was, my lord,
number.
settled for
Tiras
that. And
and
according to my lord, we are in possession of the,
defendant
my lord, root land
the
that have
receiving the premium
been from our childhood, your lord.
from the
Paragraph 7. Now, my lord, their case is that, my lord, if your lordship goes, my lord, into the plain, that on 8/10, my lord, 2006, the defendant disposes the plaintiff from the suit land. Now, all the witnesses of the plaintiff say, my lord,
Now it is Kiras Patta number 356.
our is 356, there is 61. There is 61, our is 356.
There they have got Kiras Patta now.
They, my lord, have the patta so far as Schedule 1A is concerned.
A1, A1 you have no
Or
problem.
let us say Schedule A, they have their patta one. It is 61, and tag is also
And
different.
what is the area of this Patta number 356?
4 figures and 4 figures, my lord, dear lordship.
Come record to your
About 4 figures, dear lordship, I have seen.
there is exhibit K. In fact, 4 days before, there was a judgment of the Supreme Court,
Yeah.
wherein it said that although revenue entries do not confer any title, but when the authorities who are endowed with the powers similar akin to the civil courts and passes orders, then in that regard, those orders, unless it is being challenged, are required to be respected.
So, our, my lord, this case, it was not challenged, dear lord. A is an exhibit, my lord, is Juma on the year lordship. Then you read, and we have stated that this land was settled with us. Now, this K document, exhibit K document, your lordship will find, my lord, was not telling your lordship, may kindly see, my lord, page 60, paragraph 6. And peculiarly enough, my lord, they say, on 8/10/2006, we have dispossessed them. Defendant disposes the plaintiff, my lord, it is their specific case, and that's why, my lord, they instituted the suit. My lord, paragraph 7, my lord, cause of action.
That's one. Can we apply these principles which have been stated by the Supreme Court?
Lord, so far as my lord, Jamamanti is concerned, your lord.
Hmm?
It is prima facie proof as regards possession until otherwise reverted. Now, my lord, this is 41, section 41 and 40 of the somewhere. This is a prima facie proof as regards possession until otherwise reverted. This was not reverted, your lordship. My lord, PW1, PW2, PW3 said that we did not dispossess. My lord, defendants never dispossessed the plaintiff, your lord.
See, this is a very new judgment. This may help you.
Hmm.
It was delivered on 1st of May 2024. Here it says,
And
in view of the above, so you kindly see this. In view of the above facts and circumstances, the rights of the parties over the suit land stood crystallized with the passing of the order by the consolidation officer, which became final and conclusive. The state of Bihar never challenged the said order. It is not its case that the aforesaid order has obtained by concealment of fact or by playing fraud upon the consolidated authority.
exactly.
The state of Bihar at no point of time came forward to claim the right, title, and interest of the disputed land before any forum, either the consolidated authorities or the civil court. Rather, forced the plaintiff appellant to institute the suit despite recognition of his rights by the consolidated authority. In view of the above, when the rights of the plaintiff appellant have been determined and recognized by the consolidated authority, the order of the consolidated officer is to the effect that in favor of the plaintiff could not have been ignored by the civil court. The jurisdiction of the civil court in respect of the rights determined by the consolidated stands impliedly excluded by the very scheme of the Consolidation Act. Here, section 154. The appellate court below completely fell in error in so and so. Insofar as the bar of the civil court imposed by section 37 of the AI is concerned, a plain reading of the said provision would reveal that civil court is prohibited from entertaining any suit to vary or set aside any decision or order of the consolidation court passed under the act in respect of the matter for which the consolidation proceedings could have or ought to have taken up. Here, our answer to the question framed in paragraph number 12 above is that the civil suit for declaration of right title in respect where the consolidation have already passed an order of recognizing the rights of one of the parties not barred by so and so. Civil court is not competent to either ignore or reverse the order passed by the once it has attained finality. Here in the case, you have already, there is an order being passed by an authority.
Okay.
On the basis of that, you have got a patta.
Yes.
That authority's order cannot be decided, challenged before the civil court. Can it be?
My lord, even it could be decided, my lord, for the argument sake, they say that it could be decided, your lordship. My submission is that it was issued in the year 1958. So, but by limitation, my lord, prima facie, they are two. 58, my lord.
Can it be can the order of the settlement officer or whoever it is, who did it?
Then, my lord, a peculiar plaint has been filed, your lordship. If your lordship reads the entire plaint, my lord, your lordship.
Number 5/0607 for Metik Hiraj petition, Sio Kalgasia passed an order on 27/2006 in favor of the defendants after receiving premium value of the land from the defendant with the local verification of the suit land mutated the land records in the name of the defendant. And at present, the said annual patta covered at Hiraj patta number so and so. Now, that means the annual patta which was there for the authority to issue you a patta means that the annual patta was cancelled. Otherwise, where is the question of taking premium?
Annual patta was not there. There, it is not their case that annual. Sometimes they had say occasionally that there was an annual patta in favor of the predecessors of the plaintiff. But it was never issued, my lord. Their specific case that land belongs to Harendranath Chaturthi, and he was the pattadam. Now he sold, my lord, this land B, C, and D by and my lord oral.
Oral sale.
That is their plain, my lord.
Actually, this BCD land, my lord, this was the annual patta land in favor of that is Harendranath Das and the plaintiff's predecessor. And
59, page 59.
subsequently, my lord, this land has been converted into period in favor of the defendant without, my lord, the cancelling the annual patta in favor of us.
The annual patta was issued in your
in
name.
favor of us. Annual patta
But
was
have you
ready.
challenged that? Have you challenged that?
And when we came to know, while the when we disposed it, then when we came to know, when we exhibited that exhibit 1, then that was cancelled and our name, their name has been, my lord, missing.
Have you challenged that?
That order has not been challenged, but yes, prayer is prayer in the place.
No. How can you challenge it here in a suit? In
In a
view of
suit,
154.
possibly it can be, my lord, in
How?
1990,
How can you challenge the
154, my lord.
yes, there's a complete bar.
But in 1999, our High Court has a stay. So if this settlement, annual patta, my lord, I am reading it. Right of an annual patta holder cannot be affected without issuing non-renewal notice. Settlement in respect of annual patta land can be made only after cancellation of the existing patta.
Then whom
Now-
should you make party?
Mine.
Whom should you make party in the suit?
In the suit, of course, when a stake was done.
How can you challenge the annual patta being cancelled only with the defendant?
My lord, in 154, may I read one thing? Matters exempted from the cognizance of civil court. If during subscription of annual patta, the patta holder is the dispossessed by a third party, claiming that he has been settled with the land by the government, civil suit for declaration and recovery of possession will.
Huh?
Civil suit is black.
But
Yeah.
without challenging that the cancellation of the annual patta?
That was, my lord, mutation, my lord, possibly it is
Not
gone.
a mutation. Your document of title is the annual patta. For you, that annual patta was the document of title.
That was in favor of us.
If that has been cancelled, that is why I asked that. Because the question of taking premium from them does not arise unless it is made government and then settlement is not given to them. So it is a case by which the settlement has been given to them over the land. And if the settlement is given to them, then they are bound. Unless you challenge the settlement.
154, possibly that judgment.
154 cannot. You see, the problem arises out here without a challenge to your cancellation of the annual patta. How can you have a right?
There's periodic patta.
Understood. How is it?
Right.
Your annual patta was cancelled.
Not cancelled. That is
They must have,
presume.
they have like legally, whatever may be,
Whatever.
they have cancelled it. And therefore has granted the settlement to them. And as such, these are the orders by which it has been done in 2006. 2006 that it was done and given it to them. And on the basis of that, they got the periodic patta. So without a challenge to the annual patta cancellation, because the land cannot have two things. And with the question that premium was taken from them,
Yes.
either the authority may have construed them to be the annual patta holder and given them the premium settlement on the basis of some small premium. They can do it. So if that is then done also, patta has to be challenged.
That conversion of patta.
Without that, how can it be? There's the problem. Yes, you are an expert in bench court type. For you, it should have been very, isn't it, Mr.
That's the fact.
Annual patta was not given to them. Your
Yes,
lord.
that is
My lord,
not.
page 59, plain point. And 16th line, after sale of 4 biga 1 kata 15 pesos of land in favor of Abdul Jabbar Abaduddin, state Harendranath Devadikari also said, told his share over B, C, and D schedule land orally at 90 in favor of Abdul Jabbar Abaduddin and delivered possession for it. And
Where?
Abdul
Page
Jabbar,
59?
so orally.
The name
That is
of
their source of title. They are claiming, my lord, B, C, D, and D, N. Now, lord, there is neither any evidence nor, my lord, any document.
Exhibit 456 is a document, my lord. The annual patta was
Exhibit 4, 5, 6, these are chittas, my lord, not
Yes.
admissible in evidence.
What are those?
Chitta,
Chita.
draft recording.
And Chita is, it will be taken up, but the appreciation would be different. See?
and it is discussed in page 38 also.
So schedule A land
And, my lord,
is made periodic
Yes.
in your name.
What? Wait,
He has no
no
objection with
objection,
that.
schedule A.
But schedule BCD
BCD.
land still remaining an annual patta land.
these are different.
After conversion of schedule A land, AR sold his share measuring in favor of Abdul Jabbar and opposite by registered sale deed dated and delivered possession. After sale of in favor of Abdul Jabbar, Harendra Dev Adhikari also sold BCD orally at rupees 90 in favor of Abdul Jabbar.
They are
Or
present.
Orendra
deliver.
Das, my lord, he has the share because Arnar Das,
How much land is there?
my lord,
Orally sold at
My-
90 rupees.
that part is, my lord, that cannot be
And
proved.
land
So far is that
land is about 5 bighas here. 4
So far,
kathas,
so far settlement is concerned
4
with the
bighas,
Orendra
4
Das
bighas, 1
and
katha,
predecessor
50
interest.
And what does the trial court do? Trial court also decreed the suit.
No.
Trial court partly, yeah.
BCD was not given.
Only schedule A,
A1.
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 The declaration has been given as regards schedule A.
And,
Yes,
and
yes.
schedule A1 meant.
That is A and
Entire A was not given, A1 has been.
Now, what about he is asking for declaration of what?
A1.
A1.
Only A1,
A1.
not A.
A and A1.
A1. That
Court
A,
has
A
said-
is given.
Is-
My lord,
And
my
accordingly,
lord,
A1 first question is
relief, my lord, at page 62.
He is asking for declaration of A, B, C, D.
That
BCD
was
also.
not given by the trial. My
Uh,
lord,
what was the
B,
trial
C,
court
and D
judgment?
was not given.
BCD was not given.
B, C,
Page-
and D was not.
Trial court judgment, what is given?
Trial court judgment, your lord.
Partly,
My lord,
as a
please,
result, the suit is
14
defeated
marks.
partly on contest. On the other, plaintiff, is entitled to declaration of right of A, including A and which is a part of A, and are also entitled to past possession of A.
Yes.
So A is being
A is-
given. Against that, you file an appeal.
Yes, BCD was not given.
Not
That is
given.
what-
So what does the PCD say? How does the learned first appellate court give you?
Page 38, my lord. It starts from page 37, paragraph 19.
Court decided, my lord, issue number 3 and 4. And my lord, without taking consideration of the plaintiff witnesses, without consideration of the document, my lord, and going beyond the pleading. So far as the evidences are concerned, they are beyond pleading. Now, your lordship may kindly, my lord, see page 35, the point for decision, therefore. Here it starts. And your lordship may skip and come to page 37, paragraph 19.
What is exhibit 4?
Exhibit 4, my lord, exhibit K4 is the Jamabandi of the, my lord, Patta number 51 here. And go, my lord, these are the revenue receipts, my lord, issued in favor of the defendants in the suit.
What does the Kacha sale deed have to do?
Their claim was that they purchased the land from that Horrendra Deva Adhikari.
No, that is also
That is
immaterial.
immaterial because they
We are
could
not concerned. Here
we
they
are
have
not
got a
concerned.
settlement. They got a settlement. That settlement has not been put to challenge. Have you put to challenge?
All land belongs to the sovereign law. Now, sovereign is the control. And when the my lord, sovereign issues the patta, or my lord, sometimes my lord, these tenants issue my lord, what is just
First of all, you have to show your title as regard BCD. Where is your title?
BCD is where the annual patta holder.
Where is your annual patta?
Right.
First of all, if you had the annual patta, then why was it sold at 90 rupees?
No. There are three pattadars. The pattadars, the plaintiffs, and the Horrendra Deva Adhikari. And
How did you get it from Horendranath Devata?
so far, Horrendra Deva will share mine. There are three pattadars.
You have to have your
Yes.
source of title. Where?
That portion, my lord, they sold by Horrendra Deva, that I cannot claim because that was 90 rupees, that was purchased by 90 rupees. So for my title is that I where the my predecessor were the my lord, annual patta holder. That
How?
That
Is in respect to that, whether the sale deed, what you call, is it in respect to this plot of land the Khirias Patra was issued to them?
Yes.
Well,
BCD entire mine.
Even to them, you
BCD
can't help it.
And
You can't challenge this. Take on your
we can
Assam Land and Revenue Regulation.
so far our share possibly my lord, we can check.
And
Because
how? These orders were passed when? These orders were passed in 95. When did you file the suit?
this order was
You have not even challenged the Patta.
that Keras Patta murder, that was not checked.
Huh? You have not challenged the Khirias Patta.
The Keras Patta 356, that was not challenged.
Not challenged.
But that order passed by the circle officer, that was
Nothing
my
to
lord,
do.
their prayer was.
Effect of settlement. Question is the validity or effect of any settlement or whether the condition in First, you have to show what is your business. You have to show your source of title. Anyway, देखो, heard Mr. N. Hord, the learned counsel, appearing on behalf of the appellant, and Mr. N. Hawk, appearing on behalf of the respondent. This is an appeal under Section 100 of the Code of Civil Procedure, challenging the judgment and decree dated 39/2010, passed by the Court of the Learned Civil Judge, Borpeta, hereinafter referred to as the First Appellate Court, entitled Appeal number 22/2008, whereby the appeal was allowed, thereby setting aside the judgment and decree dated 28/5/2008, passed by the Learned Munsif number 1, Borpeta, hereinafter referred to as the Trial Court, entitled suit number 1/2007. This court, by an order dated 17/11/2011, admitted the instant appeal by formulating the following substantial question of law. जो लिखी দিব হ্যাঁ 1 Roman 1 বলি আছে Roman 1 বলি না লিখবে একাই আছে on the basis of the above materials on the basis the question therefore arises in the instant proceedings is as to whether the substantial question of law so formulated by this court on 17/11/2011 is duly involved in the instant appeal. For ascertaining the said aspect of the matter, this court finds it very relevant to take note of the facts leading to the filing of the instant appeal. In brief, the plaintiff, the respondents herein as plaintiff, instituted a suit being title suit number 1/2007 in the court of the Munsif number 1 Borpeta. The claim of the plaintiff in the said suit is that one Horendranath Deva Adhikari, late Abdul Jabbar and Afazuddin were the pattadas and possessors of various plots of land which have been described in Schedule A, B, C, D. It has also been mentioned that during the last settlement operation, the government of Assam had issued the annual patta over the Schedule A, B, C, and D schedule land in the names of Horendranath Deva Adhikari, late Abdul Jabbar and Afazuddin. During the continuation of the annual patta, application was filed before the SDC Kalgasia for converting the A schedule land into periodic. And accordingly, in terms with the said application, the SDC Kalgasia passed an order on 13/5/1967 converting the A schedule land into periodic in the name of Horendranath Deva Adhikari, late Abdul Jabbar and Afazuddin. However, the Schedule B, C, and D land remained as annual patta land. It was also mentioned that the Schedule A land it was also mentioned that the shares of late Horendranath Deva Adhikari in respect to the Schedule A land was sold in favor of Abdul Jabbar and Afazuddin by the registered deed of sale number 4330/67 dated 1/6/1967, and possession was duly delivered to them. However, in respect to the Schedule B, C, and D land, orally, the said land, orally, the shares of late Horendranath Deva Adhikari was transferred at ₹90 in favor of Abdul Jabbar and Afazuddin, along with delivery of possession. The plaintiffs claim that during the lifetime, Abdul Jabbar and Afazuddin were the absolute owners of the Schedule A, B, C, and D lands. However, upon their death, the plaintiffs continued to exercise such rights. It was mentioned that on 8/10/2006, the defendants who had lands adjacent to the plaintiffs dispossessed the plaintiffs from the Schedule B, C, and D land, and also a portion of the Schedule A land. This portion of the Schedule A land have been specifically described in Schedule A1. It is under such circumstances the suit was filed claiming right title and interest over Schedule A, B, C, and D land for declaration that the defendants did not have title over the Schedule A, B, C, and D land for recovery of first possession in respect of Schedule A1, B, C, and D land, and for declaration that an order passed by CO Kolgosia dated 27/9/95 in connection with Miss Petition number 134/95/96 and the order dated 18/4/95-96 in connection with Miss Petition number 790/95-96 was illegal, null and void, and not sustainable in law, and accordingly for issuance of a precept. This court at this stage finds it very pertinent to take note of that an order of the settlement authority of the circle officer Kolgosia was challenged. However, neither the state of Assam nor the circle officer was made a party to the said suit. The defendants, upon the filing of the suit, the defendants filed a joint written statement stating inter alia that the suit land stood in the name of Horendranath Deva Odhikari and possession was transferred in favor of the defendant's father, Abesh Ali, about 40 years ago. It is also mentioned that the suit land was mutated in the name of the defendants on 19/8/1996 with reference Miss Case number 790/95-96 passed by an order by Circle Officer Kolgosia for a plot of land measuring 1 biga 3 katha 4 lechas of tag number 295, KP Patta number 61 of A1 schedule land of the suit. On the other hand, it should have been actually mutated in the name of defendant. But tag number 61 is your land.
Not mine.
Actually was in the name of the plaintiffs, it should have been, no? Also stated that the suit land was mutated in the name of the plaintiffs on so-and-so by document number so-and-so of that of A1 schedule land of the suit land. On the other hand, annual DAG number 296, 297, and 298, which are the schedule B, C, D land, was in the name of Horendranath Deva Odhikari, and he transferred the land to the possession of the defendants about 40 years ago. And the defendants thereupon mutated their names in the record of rights. It was also mentioned that before filing of the suit, the said annual DAGs, annual patta, annual DAGs, and the DAGs in the annual patta was converted into Khiraj patta. In terms with the order number CP number 5/0607 by the Circle Officer Kolgosia dated 27/2006 in favor of the defendants after receiving the premium value of the land from the defendants with local verification of the suit land and mutated the land records in the name of the defendants. And at present, the said annual ducts were converted into Kiraz Patta number 356 of village Rampur, Moza Titapani in the district of Borpeta, Assam. It is relevant to take note of that this Kiraz Patta number 356, so issued in favor of the defendant, has been exhibited as Exhibit K, na? Okay? K. The defendants completely denied the case of the plaintiffs and contended that the plaintiffs were never in possession of the Schedule B, C, and D lands. On the basis of the said pleadings, the learned trial court framed as many as where do I get the issues?
Page 10,
Page
10.
10.
5 issues.
As many as 5 issues. Issue number 2 related to whether the suit was barred by limitation, semicolon. Issue number 3 related to as to whether the plaintiffs had right, title, and interest over the suit land. And issue number 4 was as to whether the plaintiffs are entitled to recover degree of khas possession over Schedule A1, B, C, and D. While deciding the issue number 3, the learned trial court came to an opinion that the defendants had right, title, and interest over the Schedule B, C, D land in view of the issuance of the patta in their name, and the plaintiff had right, title, and interest over Schedule A land, including the Schedule A1 land, which is a part of the Schedule A land. In view of the discussion in respect to issue number 4, issue number 3, the issue number 4 was decided holding that the plaintiffs were entitled to recovery of possession of Schedule A1 land. And not in respect to Schedule B, C, and D land. The said judgment and decree was passed on 28/5/2008. Being agreed, an appeal was preferred by the plaintiff before the court of the civil judge Porpeta, which was registered and numbered as title appeal number 22/2008. The learned first appellate court decided the issue number 3, reversed the decision in issue number 3, and decided in favor of the plaintiff. However, in doing so, did not take into account that a periodic patta was issued in the name of, in favor of the defendants, which is Exhibit K. Under such circumstances, the instant appeal has been filed. Under such circumstances, the appeal was decided in favor of the plaintiff. Being agreed, the instant appeal has been filed. By formulating, an appeal has been filed, which have been admitted by this court by the order dated 17/11/2011 by formulating a substantial question of law. This court have duly heard the learned counsel appearing on behalf of the petitioner, Mr. Appellate, Mr. N. Dhar, and also Mr. N. Hawk, the learned counsel appearing on behalf of the respondents, and have given due consideration to the respective submissions. During the course of the hearing, it transpired that the patta which have been issued, Hira's patta which have been issued in favor of the defendants have not been put to challenge. Certain orders of the circle officer have been put to challenge. However, the circle officer was not made a party to the suit. Exhibit K is the said patta. It is also relevant at this stage to take note of a recent judgment of the Supreme Court in the case of Ram Balak Singh versus State of Bihar and another, reported in 2024 SCC Online ST 725, wherein the Supreme Court while dealing with the rights recognized by the consolidation authority, in terms with the Consolidation Act observed that under the scheme of this Consolidation Act, the consolidation authorities are fully competent to deal with the issue of title over the land under the consolidation, except under certain contingencies. It was further observed that the consolidation authorities have the power of the civil court to decide the question of title, subject to judicial review by the High Court under Article 30, subject to exercise of the subject to judicial review. It was further observed that revenue entries are not documents of title and do not ordinarily confer or extinguish title in the land. But nonetheless, when the revenue authorities or the consolidation authorities are competent to determine the rights of the parties by exercising powers akin to the civil courts, any order or entry made by such authorities which attains finality has to be respected and given effect to. In the instant case, it would be seen that pursuant to the order passed in CP number 5/06-07, dated 27/2006, the respondent, the state authorities, the state revenue authorities had accepted the premium from the defendants and granted Hiraj Patta number 356 in favor of the defendants in respect to Schedule B, C, and D lands. This court further finds it very pertinent to observe that although the plaintiffs claimed that they had rights over the Schedule B, C, and D land on the basis of some annual patta being issued, but with the issuance of the periodic patta in respect to the same lands in favor of the defendants by the state of Assam, by the revenue authorities of the state of Assam, and the same not being challenged in accordance with law, the rights, if any, in terms with the annual patta had ceased to exist. Under such circumstances, the learned First Appellate Court was not justified in holding the issue, in deciding the issue number 3 in favor of the plaintiffs insofar as the Schedule B, C, and D lands. That too without taking into account Exhibit K. In that view of the matter, the judgment and decree passed by the learned First Appellate Court suffers from perversity, inasmuch as the same have not, inasmuch as the learned First Appellate Court completely failed to take into account the said aspect of the matter which would, if taken into account, would have changed the course of proceedings. Consequently, the question of law which have been framed by this court, formulated by this court by the order dated 17/11/2011, is involved in the instant appeal. Accordingly, the instant appeal stands allowed with costs quantified at rupees 25,000. You have got A1 land. A1. Good money. How long the suit has been pending? Okay. Cost quantified at rupees 20,000 for the instant proceeding. In addition to that, the appellant herein, in addition to that, the appellant herein would be entitled to the cost only for the appeal proceedings. The cost in the appeal, in the first appeal. The ratio shall return the apply. The set aside in cost, the learned and the judgment accordingly, the judgment that is duly involved in the instant appeal, and accordingly the judgment and decree passed by the learned First Appellate Court, it's set aside and quashed, and the judgment and decree passed by the learned trial court, dated so and so, in title suit number so and so, is restored.
Okay.
Yes, madam.
is aspect of reversal matter.
Oh,
The multi trial court file ticket dismissed from the plaintiff matter. We were defendant before the trial court. Respondent plaintiff. My lord, the facts leading to the appeal is this, my lord. I would like to cite
yes.
plain.
You look very unhappy. Tell me. Tell me. You had a plea of adverse possession
Yes, madam.
that was rejected.
That was the trial court, my lord, allowed, but the appellate court, my lord, refused.
Why?
At the findings of the appellate court is this, my lord, the plaintiff purchased the suit land by registrar, sold it, and delivered possession. So in case of land where value is more than 100 rupees, must be affected by registered instrument. But the fact of possession that given by the defendant through their evidences, that has to be debated, my lord. So from the
No,
plaintiff
wait.
itself,
You were the defendant.
yes,
The suit was dismissed.
it was the original, like prior to the,
You came in appeal.
no,
He came in appeal.
deferred.
And that appeal, which was allowed.
Deferred
Now,
decision of the
you had the case of adverse possession.
yes,
That
Yeah.
adverse possession was not taken into account.
by the appellate.
So therefore, you must have claimed adverse possession against whom?
Against my lord, the plaintiff, my lord.
Well, let us see your written statement.
Yes, my lord. My lord, from the plaintiff lordship will fight, my lord.
No, plaintiff is he. We are concerned with adverse possession.
Yes, my lord, from the plaintiff itself, my
No,
lord.
no. Adverse possession is yours. It is you
But they
who
need
have to prove it.
they said that, my lord, we have dispossessed them. So before one needs to prove the allegation of
You
possession
have
before.
dispossessed them very well, but where is
Needs to
your
prove the
feelings?
possession before allegation of dispossession, my lord.
Where
They were
let us
dispossessed.
see first your written statement.
Yes, my lord.
Written statement of defendant number 1 and 2.
That
Where?
page
Where? Page 21,
Page
64,
64.
64. Starts and ends.
And
The plaintiff never possess the suit land in question as because they do not live in village Moirabari or in Sagunbari Pathar village. The averments made are denied and defendant in as much as the plaintiff never came to the possession of the suit land. The registered fairly mutation was made behind the back of these defendants who were continuously possessing the suit land from 1993 by constructing dwelling houses of permanent structure. The real fact, the defendants are local indigenous people permanently residing at so-and-so Pahar within a defendant purchased the other lands from Iman by registered sale deed apart from the suit land. The defendant verbally purchased the suit land from Ikram and who promised to. Who is Ikram?
Ikram, my lord, Ikram is the one that pro forma defendant. my lord.
Okay. So he's not the plaintiff. Who promised to execute the registered sale deed afterwards, and the possession of the land was duly handed over to the defendant in presence of prominent local people and the village headmen. The defendants, after possessing the land, demarcated the land by planting various plants in the border and constructed dwelling houses of permanent nature and used to live there with families of the knowledge of the household. The land revenue are also paid by the defendant. The defendants have uninterrupted continuous possession in the suit land from 1993 to any objection of any person or real owner. If any right existed, then it is extinguished by the existence of the real. Okay. Then,
My lord, from the plaintiff lordship will fight, my lord.
where is the plain?
Page, my lord, page 54. We are the principal defendant, number 1 and Then my lord, pro forma defendant, my lord. My lord, may I read
Hmm.
paragraph 1, my lord, out of 10.
Yeah.
A plot of land measuring 4/5 lesser out of 1 bigha 0/13 lesser covered by dag number 66 in periodic patta number 10 at village Soguntai Patta under Moja Moirapuri in the district of Morigao, Assam is the subject matter of the instant suit. My lord, in that 10, my lord, that schedule has not been mentioned, my lord. 1/13 lesser schedule is also not given. Then 5 lesser 4/5 lesser schedule is given only. 1 bigha 13 lesser schedule was not mentioned. Then, my lord, paragraph 2, my lord, that the Sud Patta land originally belonged to one Akash Ali. One Akash Ali was the original owner of the land measuring 1 bigha 13 lesser, covered by dag number 66, periodic patta number 10, including land of other dag of the same Sud Patta land to pro forma defendant number 4, 6, 7, and 8. But at 1, 5 are the same person. Fazila Khatun. 2, 3, 4, and correctly obtained mutation as Patada number 2 and 2. Had ordered dated 16/12/84 passed by circumstances. Again, pro forma defendant number 2 and 3, Muhammad Sohidul Islam and Ikram Hussain, both son of Samsul Haq, purchased 4/5 lesser land covered by dag number 66. From the above mentioned, named pro forma defendant number 6, 7, and 8, Sofikul, and Moinul, son of Fazlul Haq, and they got mutation of the state land accordingly by order 22. Number 3, that then the above named Patara number 11 and 12 has been possessed as suit land along with other co-sharers, brothers and sisters. They sold the suit land measuring 4/5 lesser covered by dag number 66, Patta number 10, village Sogunbai Pathar of Moirabari Moja, along with other portion of land of dag number 65, 1 bigha 2/1 lesser, and 2 bigha 3/9 lesser covered by dag number 78 of the same Patta land, had executing register deed number 16697 in favor of the plaintiff and delivered.
Who is Patada number 11 and 12?
11 and 12 is the, my lord, pro forma defendant number 2 and 3. My
2
lord,
and 3.
my lord, the thing is this, my lord.
2 and 3 sold the by way of a registered sale deed in favor of the plaintiffs
Yes, my
in
lord.
97.
All the 4 brothers and sisters. In the plate, it has stated, paragraph 3, all the 4, my lord.
Where?
My lord, paragraph 3. Then the above name Patada number 11, 12, that means pro forma defendant number 2 and 3, had been possessing the suit land along with their co-sharers, brothers and sisters. Co-sharers, brothers and sisters means, my lord, Tafazul Hussain. My lord, originally, my lord, it is very confusing, my lord. Akash Ali was the original owner. Then, my lord, from him, the pro forma defendant number 4, Tafazul Hussain. Pro forma defendant number 4, Tafazul Hussain, son of Samsul Haq. Then 6, 7, and 8, Rotikul, Sofikul, and Moinul.
Now, wait. In your written statement, you say that in 1993, you purchased by a Kacha sale deed.
Yes, from pro forma defendant number 2 and 3.
Is performer defendant number 2 and 3 sold it to the plaintiff?
Yes, well, subsequently by all the brothers and sisters.
Whatever may be.
In common.
Absolutely understood. So in 1993, you recognize the performer defendant number 2 and 3 as your owner?
Yes.
When was the suit filed?
The suit was filed in the year 2007.
Then?
My lord, I am coming to that, my lord. My lord, in the sale deed, Lordship will find that is exhibit 2 in the sale deed that was executed, my lord, in the year regarding, my lord, Imran Hussain and Iftikhar. At that point of time, their occupation was known as Kiki.
I'm not on, you have not challenged those sale deeds, madam. We are only on the question. One question of law has been played.
Yes.
As to whether you have proved your case of adverse possession should have been taken into account.
Yes.
Now the question is, you in 1993 claimed that his vendor were the owners of the land. When did it become adverse? Where is your state?
My lord, since 1993, we have been positioning.
Now, you claim that he was the owner in 1993.
Yes.
Thereafter, you are claiming you are residing out there. That's a different thing. I'm not concerned with
I
that.
had no knowledge.
Well, residing a long time does
If
not
he,
give
if
you.
he sold the land to some other else, I had no knowledge. I have been continuously possessing the land.
So
Till
what?
date, having my
Whatever
residential
may
house.
be, you have no knowledge that he is the owner. That makes you case more bad.
No, we have been possessing the land with the knowledge of our original owner.
Who is the original performer defendant number 2 and 3?
PNC.
And from performer defendant number 2 and 3, you claim that you have purchased in the year 1993.
Yes, through oral.
Whatever may be, you claimed in your plea. Under such circumstances, have you stated from which date it has become adverse to those performer defendants? In your
My lord, yes, my lord.
No.
2893, my lord.
No.
From 2893, my lord, in our.
It is
evidence-
something like this, madam. One day I went to Pasigat. No, not Pasigat, Tezu. I asked the persons, and there was no good hotel at that point of time. I don't know now you have. So they said that this hotel is very nice. You can go out. I said, okay. And I asked them, what is the amount? How much you asking? So he said, 250. Then I said, what is type of this room would be 250 as the rental? Then I went out there and saw the moment I entered the room, it was almost ended. Your written statement is like that. It starts even finishes. 3 paragraphs. And you are asking for adverse possession.
My lord, till now we have been possessing the land.
So what? That is why he's filed the suit for
My lord,
evicting.
plaintiff number
You gotta
1 and
stay.
plaintiff number 1 and 2, they are doctor and engineer, and they have never in possession of the land from the.
Hello, we
CWs.
do one thing. Today is a Thursday. We won't dismiss it. We dismiss it on Tuesday. Next Tuesday. Matter have been heard at length. List the matter again on Tuesday. Tuesday next day at 2 p.m. Dismissed on that. So today not.
Without cost.
Huh?
Without cost.
Cost is 11,000. You are a poor man. If it is poor, it is 11. If it is good, then it is more. But you have been enjoying the possession all this while. His land. So don't you think that it should be something around 75?
The land, but they are not in possession of the land, and they have.
Maybe that is why they have filed a suit for possession. So we make it something around 75. How's it?
They are very illiterate, my lord. But they
Illiterate,
are doctor and engineer, my lord.
illiterate and being possession for
Their
all
father
these
is
years.
also advocate.
Just take it 500 rupees per month also, it will be
Oh,
75,000.
sorry. Must have like.
Yes, any matter to be taken? No more. Take it. Where is it? WPC. Oh, yes, WPC, Mr. Nayak. What is this matter about? Oh, that matter. Yes, why this matter? It's a pattern matter. Why it's not come up on the top? Yes, tell me.
My lord, Peru's order dated 13/2.
Yes, you don't have a case. You don't have a case.
My lord, they have not been able to produce that notification.
What notification is
under
required?
Section 40.
Huh?
Whether that case is within the city of Bahad.
No, they said Mr. Pianan appearing on submitted that the area of Pachim Boragaon has been included within the city of since its inception.
And he would produce.
And he would
No,
produce the
ma'am.
materials on the basis of which he has made the submission. According to list the matter on so and so. Yes, you have not filed your affidavit.
Affidavit I have not filed, but
You have got the
one
paper?
notification is there, Lordship, which will show that even prior to the notification of 1992, Pachim Baraga was within the GMC.
Yeah, matter in.
This is a notification under Section 43 and not.
No, we are not testing the notification.
We are not testing the material.
We are only
We are
going to
not
show-
going. So we close it on that way.
Lordship. Page 27, Lord.
Page 27.
Internal page number 9. Lordship will see word number
Poragao, NC, Postim Poragao,
Oh.
area included, ward number 10.
Lord, the
Huh?
GMC Act, section 42 and 43 for
43.
it's under 40.
In exercise of the
Delimitation
powers conferred
of
under
the ward.
subsection 1 of the read with the notification dated I so and so with the approval of the government by number 1973 hereby divide the city of Guwahati as notified in Guwahati so and so into 34 wards for the purpose of is a notification of 73.
yes, Lordship.
Section 42 for
The
Why?
42 is not
because
necessary.
it is a notification by the state government. And it's not a notification by the state government, it is by the GMC.
No,
They are
Lord-
delimiting the wards.
no, what we only need to show that at that time when this notification of 1992 was issued, GMC was within the Paschim Baraga was within the GMC area, Lord.
You see, in exercise of the powers conferred by subsection 1 of section 43 of the Guwahati Municipal Act, read with government notification number MA 21/73/98 dated 14/6/73. I so and so, with the approval of so and so, divide the cities. This notification he has divided the
Right.
into wards. But there is already a notification
There has to
of
be,
the
and that
government.
notification has to be
That
produced.
notification I have not found yet, Lordship.
But that notification will
One
be there.
notification will be there, but
Yeah.
here, Lordship, page 72, Lordship.
No, you are coming now in the year 2014. And as on 73, it was already there. Paschim Baraga.
Yes, that is the only.
You are not challenging the incorporation of Paschim Baraga within it.
Yes.
Are you?
Yes.
Where?
Two parts.
Let us see. Where have you done Paschim Baraga within the ambit of this? Where?
Paragraph 10.
No. Where's the relief? Where are you challenging those notifications of 1973? That it could not have been brought. Your simple question is composite zone and all these things. It should not have been that the GMDA master plan cannot be made applicable out here because of the fact of
page
section
72. Page 72, Lordship.
Page
It's the
72.
1992 notification, Lord.
Yeah.
Lordship, may kindly just
Is
see the
hereby
middle
pleased to
portion.
declare that the greater Guwahati master plan as described in Umayan district so and so, Kamalpur and so, Guwahati Municipal
Municipal
Corporation.
So
Your
area,
basic case is Paschim Baraga at that point of time was never a part of it. That was your case. But Paschim Baraga was there from 1973.
They have to show, my lord, that notification
This
is
is it.
being on record. This is a delimitation of the ward, my lord. It's not a notification.
Are you challenging that they don't have the notification?
They have to produce it before the honorable court. Because it's not just issuing a notification. There is a process under section 42.
No. We are not going to challenge, see the
I'm-
process. I'm making
Yeah,
it big.
I'm also not there. If they can
We are
show
only going to look into as to whether there
there
is
is a
a
notification by the state
Now
government
it's
under
on
section
DMPA.
42.
Where is your averment that there is no notification under section 43?
10C, my lord, paragraph page 12.
There are 10,
C.
10C.
10.
Then,
It's not set.
And then can
This is
see
the
my lord.
paper that Lord
Huh?
will see the prayer. Lord will see the prayer only.
no, where is it mentioned out here? It won't into this.
Then can E.
10?
Can E. Page 15.
Why you mention, however, the authority of the GMDA under GMDA Act cannot extend behind the Guwahati municipality area. What is this Guwahati municipality area?
70. Page 72.
No, what is municipality?
What is municipal corporation?
No, because there is because you have to understand,
What is
prior
municipal
to 73, 71, it was Guwahati municipality. There's a difference out there. Now it became a corporation in 1971. Yes, tell me. But that is not your case at all. Once the land now falls within the ambit of the Guwahati Municipal Corporation,
they-
your entire case
just have to
hinges
show-
upon that, you see, they have extended, it was never a part of Guwahati Municipal Corporation. Now, if Pusin Boragam was within the scope of Guwahati Municipal Corporation, within the ambit, the matter ends there. And not to say that, the most pertinent aspect, how are you aggrieved?
Or they have changed the land use. It was a
You are
industrial area.
still, you don't have any problem. You still don't have any problem.
I had.
No.
My land value has been decreased. I
No.
cannot sell it to for any other industrial purpose. I cannot use the same plot of land for any other industrial purpose. If I change my industry from jute that I'm using now, I have to take permission from them. They will say, no, this area does
That
not.
too,
fall-
you have to take a permission if you have out in anywhere in the Guwahati municipal area, you any permission, any industry you set it, you need to take a permission.
If it is an industrial area itself,
Hmm.
I get a loan, which I cannot get now if it is a residential area.
Why you
It
can't
is
get a
not-
loan?
it's for an industrial setup, because they will say, you cannot set up an industry here. It's a composite zone.
No, no.
And tomorrow,
Any industries which are continuing out there, that will continue.
exactly. So if my industry continue, the same industry continue, it will continue. But if I change my
You want to
industry,
change it.
I may.
So
we
why
want to-
should we look into now that you may change it? You're not going to look into all these things. You want to change it today, you may not change it. These are all things which will happen at that point of time. File an affidavit that you want to change it,
I'll
change the use.
do.
But if that
You want to
objection-
close
objection-
your factory and open some other industry. Come up with an affidavit.
Because we were aggrieved because the residential area building was permitted. Just adjacent to our product.
So?
So tomorrow they will say. that
Your
this industry is
submission,
producing
Mr. Mishra
pollution.
made the
I'll-
submission to
I'll-
that effect.
I'll take that.
Mr. Mishra made the submission on the last occasion, if I remember, is that the moment today, if this industry we continue like this, tomorrow they may come up further change. They make further change in the master plan. Now they have made it composite 2. They may further make it residential because now there are residential houses there.
Yeah.
So I said, isn't that too far-fetched? Whether they will come up and change, then it is a question to challenge
Yes.
your rights
In
being affected.
2014, it cannot be challenged. Notification was issued in the year 2007 itself. Newspaper publications were there. They never came forward, Lord. Now,
No,
After
wasn't it,
everything-
Mr. Naik, that submission made at that point of time by Mr. Mishra when I was taking up
Yeah.
this matter?
Doctor, their first submission was that it is not in terms of the GMD Act 1985 by following the terms of Section 3. So that is why the 1992 notification is not a proper declaration. So GMDA cannot exercise as an authority. So it has no power to declare the master plan. That is their basic issue, Lord. But Lordship will see one paragraph only, 10D, page 13. Own statement, petitioner statement. Paragraph 30, page 13.
Yes.
10D, down below, Lord. That the impugned notification dated 23/3/1992, bearing number so and so, issued under Section 3 of the GMDA Act. This is contrary to the pair made in that same writ petition, Lordship. Lordship may kindly see the pair. Page 24, paragraph 3. So at the same time, they are saying it is a declaration under Section 3, but they are opposing it,
No,
saying that
no,
this
Mr.
is no
Naik,
declaration.
that was never their contention. Their contention was face free. This land was never within the ambit of Guwahati Municipal Corporation.
Yeah.
They therefore say,
that is the second submission. In the 1992 notification,
Hmm.
3 revenue areas included in the final master plan of Guwahati.
Hmm.
First one is Guwahati Municipal Corporation.
Hmm.
It was their stand that the Paschim Baraga was never within.
never within that. And
that is
therefore they say that the earlier town planning things which was given in 1989, 89 or earlier,
1986.
that was given out there, that could have been given out there, but this one notification could not have been given because this area was never within the Guwahati Municipal Corporation.
Yeah.
It is under such circumstances I asked you as to as to how is it possible. Then you came up out there and said that look here, this is it was from its inception, Paschim Baraga was.
And that 73 notification is there. It reflects that Paschim Baragi was within the GMC area. So that is the only, the query law.
(42)(1) does not require anything. 42(2) and is subject to 42(3). You see, the power to issue a notification under subsection 2 shall be subject to this. Subsection 2 is for enlargement or changing. But if it was there, then there is nothing. There's nothing out there on the basis of that notification.
Notification under section 40. So they just have to show the notification. To be specified by the state. This notification is by the commissioner again. Page 38.
Pursuant to the order passed by this court on 13/2/2024, Mr. P. Naik, the learned standing counsel of the GMC and the GMDA, had placed before this court a notification issued by the Commissioner Guwahati Municipal Corporation, which is in terms with subsection 1 of section 43 of the Guwahati Municipal Corporation Act 1969. In the said notification, there is a reference to a government notification number MA 21/73/9A dated 14/6/1973. This court fixes the matter again. When do you want it? How much time? Conclude it.
It's very difficult to find out this notification. Now, Lord, I somehow managed
No,
to
this
find
is the
out.
most important notification. It should be kept in archives properly. That day I could get hold of a very important notification, the settlement rules of 1971. So he gave it to me in this manner. So it was very torn up because it's done 6th of April 1931. It's the original one. So I could get hold of it. I scanned it, everything, and then took a printout and now made. So you should also do something. We'll have it on 3rd of June. No, I won't be there. We'll have it on 30th of May. Is it possible?
Lord, it will be 4 weeks time.
Then
I'll
we'll
try.
fix it on 18th of June. List the matter on 18th of June, on which date Mr. P. Naik, the learned counsel, shall produce the notification number, the notification issued, the above notification issued by the government. List the matter at the top of the list on. You keep this for the time being. Very difficult.
Not I have.
Pilot, item number 12, can I JPC?
What?
In respect of item number 12,
What is 12?
civil revision petition matter, I am the plaintiff decree holder.
What is this matter?
Pilot, eviction.
Landlord tenant.
Yes,
You are the tenant.
I am the plaintiff decree holder.
Landlord. Okay, suffer more. What has happened, Mr. Naik, about the Tenancy Act? Any idea? Why it has not yet been notified? This is most essential. The Assam Tenancy Act, why it has not yet been notified? It is a very important, yeah, because you see, 1972 Act has gone archived. That act, the law has completely changed, and this is a very modern one, taking into account the interest of both the landlord and the tenant and all. These type of matters, you see, otherwise it becomes, it should be always in never-ending disputes between landlord and tenant. Take years. And the laws which have been followed, all these earlier laws, were laws at that point, and you see the 1972 Act, or all these acts have been made only on the basis at that point of time the World War II was going on. 1972 Act is just a copy of those laws which were made that World War II, what was happening, there were a lot of people these people were having a lot of difficulties, and the landlords were trying to evict. And it is for protection of that, these acts were being made. In Assam, we copied it out in very late in 1972 by following that law. We are almost 80 years now. Following the same. Becomes very difficult. Now, bona fide requirement. The question of bona fide requirement has gone for a 6. The recent Supreme Court judgments, it makes it very clear that absolutely the landlord's domain as to whether he wants it or not. And that is the matter on which I think his case is also pending.
Defaulter and bottom.
So, what is it? And the law is very clear now. But it has to go through the process, the long process. But the Tenancy Act gives a very good measure. Like in Delhi and all, you have the rent control legislations which are much faster. Here, the civil courts have no time. Just find out why this has not been. Most probably after the elections, anything will happen. But I think this needs to be pursued. Yes, Mr. Tinath, you're the senior government advocate. Something needs to be pursued with that act, Assam Tenancy Act. Because it has been done, everything has been done. It is done in the right spirit. It needs to be brought in. I think that is why you have not framed the rules. Because the moment the rules comes in, the question will come.
That's it.